Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today's Wednesday, February 18th, 2026. We have 12 bills on the docket, and we are going to start off with Senator Washington with Senate Bill 604.
Good afternoon, committee. Good afternoon, Chair, Vice Chair. This bill is codifying Maryland regulation when it comes to our policies around non-discrimination, when it comes to individuals who offer themselves to participate in our foster care and our adoption and also doing public service. For the record, I'm State Senator Mary Washington, and I'm here to present Senate Bill 604. And as we know, Maryland has long been a leader in protecting the rights and dignity of all Marylanders. This bill will ensure that we remain the same. The core protections in SB 604 are not new. And as I just stated, they codify existing protections into statute. If anyone wants to look it up, it's COMAR 07.05.03.09. So this bill prevents anyone from, it prevents us from rolling back or having our agencies have to roll back some of their fundamental practices. It also adds gender identity and aligns it to Maryland's adoptive placement standards. So it makes sure that our foster care, our adoption, and our public services are all aligned and codified. So beyond adoption, the principles to foster care and provide public services, so that are also anyone who is a social worker, anyone who's providing any type of supportive services via contract or employment have the same protections. So basically any state-funded agency or employees cannot deny based on the protected classes. The bill does not alter existing religious exemptions. Let me say that again. This bill does not remove or alter existing religious exemptions, and it does not change the vigorous vetting process that we engage when people wish to adopt or wish to participate in our foster program. So every single aspect that we consider or have that we require to ensure the safety and welfare of the children in our care who are wards of the state, all of those protections are maintained. So we have seen, obviously, tremendous amount of efforts at the federal level to roll back the protections that our community experiences. I'm grateful, my wife and I are grateful that we live in the state of Maryland. And we don't have to worry about, well, our children are over 18 now, and sometimes we do wish somebody would take them away. No, I didn't say that, but there are, you know, we are just very grateful that and happy that that's not something that we have to worry about. But again, that's not the case for everyone. This is making sure that Maryland standards remain Maryland. Every child deserves a family. Every person that's willing to be the family for a child in need of a family should be allowed to do so, or at least they should be given a fair chance. I respectfully urge your favorable report, and I'm here to answer any questions. I don't have a panel.
Excellent. Thank you very much, Senator. Senator Sidner has a question.
Good afternoon. You touched on this a little bit, but I want to see if you want to talk a little bit more.
Okay.
Have you seen the Catholic conferences? I'm looking at the Attorney General's that says similar to what you said. This is essentially just codifying
Existing practices.
Nothing
new.
They seem to be from my read of what their testimony, they seem to be saying that it's more than that.
Again, that's why I gave you the codification. Of course, law is going to look slightly different. We're going to structure it differently, but This doesn't change. What this does is put into Maryland law what our agency is already doing. Also, Catholic Conference has what they are able to do and what they wish to do goes unaffected by this law.
Thank you very much.
But thank you for that opportunity to clarify that.
Thank you very much, Senator. Seeing no further
thank
questions. Thank you. Excellent. With that, that'll conclude the hearing for Senate Bill 604. We'll go on. Senator Jennings is here. We can go on to Senate Bill 576.
Thank you, Mr. Chair. Distinguished members of the committee, Senator J.B. Jennings for Senate Bill 576. Just as a review, this deals with the reserve funds for condominiums. This is an issue this committee has dealt with for several years. Goes back all the way to the tragedy that we had at Surfside collapse in Florida several years ago. Last year we had a very comprehensive bill. I had a bill that came in. I know there were several bills, and I think you guys put them all together in one bill. I think Delegate in the House, actually, I think he used his as the vehicle to pass it. But there was one issue in there that had passed out of it, which basically allowed for deviation from the plan to be used. And since that time, I've gotten some contact from some of the communities saying they had some concerns with the way that they allowed these communities to deviate. And basically, they wanted to kind of clean it up and to ensure that any deviation would allow the use of these reserve funds for emergency situations only if they deviate, and that these decisions to use these funds be made by the community with a 2/3 vote. And it's making sure that we're using the funds properly and that the way that they need to. I do have, are you guys going to testify? I do have witnesses here that will testify, but that's pretty much what this bill does. It's just trying to, narrow the scope of how they can use these funds in an emergency situation. And, there were some concerns from some of the communities that was kind of a loophole that was some of the way it was drafted last year that will allow the boards to make decisions on how they could use some of these funds. And we're just trying to clean that up and not allow that loophole. Without transparency and making sure that the whole body of a community has its vote on how it's being used. So with that, I just ask for a favorable consideration, Mr. Chair.
Sure. Do you have a sponsor panel you'd like to bring up, or just the?
Yeah, I apologize.
Excellent. No worries.
Like to come on.
And ma'am, you can testify while seated if that's best for you.
You know me here.
Do you want to sit down or do you want to stand up?
Well, I can stand, but I may run over the 2 minutes.
No, go ahead and sit. Ma'am, you can go ahead and sit down. You can have.
Can I
take
sit down?
Yes, yes, ma'am.
I have a metal rod up my leg, so it's hard for me to go up and down. So, I guess, will that hear me on his? Yes, yes. Okay. Okay. Good afternoon, Chairman Smith and Vice Chairman Walt Stryker. My name is Jeannie Polhouse, and I am a condo owner in Baltimore City. I'm here to testify in favor of Senate Bill 576, sponsored by Senator J.B. Jennings. Senator Jennings worked so diligently with us last year in assisting us in correcting some financially harmful legislation for condo owners. A good portion of condo owners are elderly and have spent their lives raising and educating their children, have moved into condominiums because they are at an age where they are unable to handle the exterior maintenance of a home and grounds. The idea of having someone else take care of the exterior of their home seemed like a good way to transition into retirement. However, over the past few years, we have been bombarded with legislation that is putting financial hardships on these owners. I live in a 2-bedroom condo in Cross Keys, and my condo fee has gone up $200 per month in the last 2 years. Add that on top of escalating gas and electric fees, rising taxes, and other fees, you are slowly doing away with condo ownership. Senator Jennings understands our concerns and has been willing to help us. This bill does just that by correcting Senate Bill 63, so we will definitely support his efforts. By allowing withdrawals from the reserve fund for emergencies, even though it must be paid back within 5 years, it's an essential part of that bill that's important to condo owners. And also, with any withdrawals can be made for things that are not an emergency, but those must have a positive vote from 2/3 of the condo owners. And that's to protect these runaway boards that will just take money out for any reason whatsoever. Many of you may not realize that condo ownership in the state of Maryland is approximately 30% of the housing stock. That's a lot of condo owners, and that's a lot of votes. It would be wise to consider that in reviewing other pieces of legislation affecting the condo community. We need not remind you that this is an election year, and we are taking notice of the additional financial burdens you are putting on to condo owners. Unlike many young people, we do vote, and we will vote this year. Thank you.
Okay. Good afternoon. My name is Jean Hyatt. I am a condo owner. Thank you to Chairman Smith and Vice Chairman Waltscheiker. I hope I said your name right, and the other members of committee. We're speaking about what I call the loophole provision in Senate Bill 63. Let me read that for you. It's just a sentence. 11-109.4, reserves may be used for purposes other than those specified in the funding plan if the funds are repaid to the reserve fund within 5 years after their use. The problem is there are no qualifications, no requirements here. In the 2025 state legislative session, the amendment was proposed and we thought inserted the word emergency. Just before the bill came to a vote, the word emergency was deleted. So now all we have is that a board can go into the reserve funds and withdraw money for purposes not on the funding schedule. There are no qualifications as to what monies must be used for, how much, how often, nor is there a requirement, as there is in the Florida law, for consent of the other owners. Only 3 states, to my knowledge, have this kind of provision allowing withdrawals that are not on the funding schedule, and both of those have qualifications. Under this provision, to be blunt, a board may withdraw funds from the reserve study for whatever purpose they wish, for as much as they wish, whenever they wish, and the condo owners will have no say, no knowledge. What this amendment does is it says you can do that, but only 2 purposes. One is emergencies, and there is no consent required because an emergency needs immediate remediation. The second reason is short-term expenses, and for those, you do need consent of the governed. And that's basically all this is. It closes the loophole in the law. Thank you. I hope you will vote and support this amendment. Thanks for your time.
Senator?
Okay. Thank you. I hope we're okay.
Stay here, stay here.
I wanted to just give you an opportunity. I was looking at the unfavorable testimony from Leisure World, and it says, it is not clear if, let me start over. Talking about the bill, it requires approval of 2/3 of the members of the cooperative or unit owners of the condominium to depart in an emergency. It is not clear if that is 2/3 of all members and the unit owners, or just 2/3 of members or unit owners voting in a meeting.
So I have an amendment, and I don't know if you guys have it, and if you don't, I apologize, and I can give it to council that I think fixes that.
Okay. So I guess my question is, what was your intent?
It should be, and I would.
Do you want us to?
I would leave it up to these experts right here.
What we're saying is, if it's an emergency, like a water main break, which requires immediate attention, you can withdraw monies and you don't need the consent.
What's the two-thirds? Is it ownership or?
2/3 of the
Owners.
unit owners.
Should be, I think it should be ownership, because I don't think it should be renters.
Okay. But
I mean, no disrespect, I mean.
no, it's 2/3 of all members and unit owners, or is it 2/3 of those people or at the meeting?
No.
Oh.
All unit owners, yeah.
I think it should be owners.
It's all the owners.
I don't think it should be quorum.
It's
I
not-
don't think it should be a quorum of the membership. I think it should be of the actual ownership.
And the only reason I'm asking, I just want to make sure what the intent is.
Yeah,
Thank you.
I think it's something like that. That would be something where they should probably mail it to the actual ownership and everybody then respond back.
Because there's no time
Thank you.
constraint.
But not for emergencies.
Yeah.
I'm a little confused. I'm looking at the language of the bill. It says reserves may be used for purposes other than those specified in the funding plan in an emergency if, one, the funds are repaid to the reserve fund within 5 years, and two, the use of the funds is approved by an affirmative vote
No.
of at least two-thirds of the members in good standing.
That was
This is the
taken out.
co-op portion of the bill.
That was taken out.
So in the bill as written, even if there's an emergency, you would still have to first have a vote of the two-thirds members.
No.
And that's what the bill says, unless there's been an amendment to change that.
That's what I have here is just an amendment that I think
Okay,
should have been given to the council. So,
Okay, thank you.
Chair, this may have been answered. Ladies, can you give me some kinds of emergency expenses?
Well, we had one in a neighboring,
She-
Cross Keys has 9 neighborhoods. Did you?
Direction, I want you to stand up. You're okay?
I have a bad leg, but one of our communities had a water main break, and the water main was on their property. It wasn't
Okay,
on a public
right,
road, so
right, right.
BG&E would not take care of it. They had to finance that because they were not allowed to take that money out of the reserve fund. Okay, but they needed to do it because it's a water main break. They had to do it. So they did it, and it was many, many thousands of dollars, required a special assessment, and, it was just unbearable. This way, for an emergency, you can go into that fund, take the money out. Yes, you have 5 years to pay it back, but you can spread it out. But if it's not an emergency, then you must go back to the ownership and say, two-thirds have to say okay, because it's got to be a quality thing that you're doing, not just planting a flower bed in front of somebody's condo building, it has to be something substantial.
Okay. Just as a side note, there was a show called Who Wants to Be a Millionaire, and you could phone in a friend. I think your friend here just had a question or wanted to add to that testimony. She wrote down for
I'm
you.
sorry, I'm 83 years old, and
You're
my
doing
hearing is
fine.
not real good.
Is there something you wanted to share, ma'am?
No, thank you for asking. The only thing I was going to share is, if you didn't have this, if you couldn't use the hundreds of thousands sitting there in the reserve fund,
Yes.
then it would trigger a special assessment. So you need the money, you've got 500,000 just sitting there, but you can't touch it. This would enable you to touch it, but we need this law that Senator Jennings did, because if you didn't have it, boards could go in and take the money for the flower bed. It could be for any purpose, there's no qualification. So his law says you can do it, but you've got 2 conditions. Emergency, no consent needed. Short-term operation, sure you can do it, but you've got to tell the owners, and if you explain it to them and they say yes, then you can do it. And
Perfect.
either way, it must be replayed in 5 years.
Thank you. Thank you, ladies. Thank you, Senator.
Mr. Chair, one more question for the sponsor. So the same reserve fund language appears in the law 3 times, one for co-ops, once for condominiums, and once for homeowners associations. This bill only purports to change the law with respect to emergencies for co-ops and condos. Is there a reason why you decided not to change the law in the same way for homeowners associations?
I thought that going back, I remember last year, some of the discussion, homeowners association, I thought you own that, it's a detached home, where it's not a community attached home where it won't affect somebody else, was I remember in some of the testimony I was reading. I could be wrong on that. That is what, whereas a condo, it's a joint facility. So you, Senator Sidnor,
Well, it doesn't have to be. Some condos are detached.
that
Many
was
are
explained to
in
me
a single building.
that,
Would you have a problem if we were to also add
No,
the
not
homeowner
necessarily,
association
no.
to the bill and it's subjected to the same
look,
rule?
this is your subject matter. This is what you guys know.
Okay,
I leave it up to your expertise.
thank you.
I'm just trying to address this loophole that had come up and let you guys fix it. This is not my wheelhouse. I'm upstairs writing budgets, so.
Okay. Thank you very much for your answer.
All right, Senator,
Thank you.
thank you both very much.
Appreciate
Thank
the
you all.
time.
All right, so that'll conclude the testimony for the proponents of the bill. Now hear from the opposition. We'll hear from Mr. Silverman and Ms. Robin Manogian. Go ahead. Yes, go ahead.
Good afternoon, Chairman Smith, Vice Chair Waldstreicher, and members of the committee. Good afternoon, and thank you for the opportunity to testify. My name is Scott Silverman. I'm the Vice Chair of the Community Association Institute's Maryland Legislative Action Committee, and also a 30-plus year attorney representing community associations throughout the state. To begin with, 576, the instant bill, as Senator West pointed out, does not address the Maryland HOA Act at all. Therefore, the efforts that this committee has undertaken over the past 4 years since the Surfside collapse to enact legislation to achieve parity across all community associations, that effort would be frustrated if we don't address all of the acts. However, unlike the proponents of the bill, we contend that there is no loophole. The law was drafted very carefully. It was the subject of considerable debate last year. And the provision that permits a loan from the reserve fund simply recognizes that the reserve fund is the least expensive source of capital that a board can access to meet exigent circumstances. For example, this year with regard to snow removal, say they have a huge snow removal bill. It was not budgeted for. There's no other way to meet it. It's simply better to be able to take money out of reserves that may not be needed for 20 or 30 years and pay the snow removal bill and then pay it back over a 5-year period rather than to have to go get a loan and then pay interest on that amount. That's simply what we're trying to accomplish. If there is an errant board, it should be removed. Any question?
We'll take questions at the end of the video.
Oh, okay.
You can have a seat.
Thank you.
Hi, good afternoon. Thank you, Chair Smith, Vice Chair Waldstreicher, and the committee. My name is Robin Manogian. I've been before this committee before on many condo issues. This one is a problem because, so remember why the reserve study bill came about. It was following the collapse of the Champlain Towers in Florida. That problem, and Florida has since corrected their law, and I would hate to see us go back and have a problem again. So the way that Florida law was written back when that collapse happened, the law required that associations reserve for capital improvements, but with a certain majority, 51%, the owners could vote not to fund. And so I would hate to see us reinsert any language. And yes, you can take away the emergency, but what qualifies as an emergency? So Champlain Towers started to have problems well before the collapse. We had a local engineer go down and determine in 2018 that the building was failing. That board attempted to get the association's members on board to start funding, and each and every year they shot down the funding. Then you had successive board members resign because they could not get the funding. So we feel, and I agree with my colleague, we have worked on the reserve study bill across the country. Maryland's reserve study bill is very robust. We first looked at Delaware's, and it's that reserve study plus the funding that safeguards communities. Are there boards who may be dipping in for the wrong reasons? Sure, but it's the exception, not the rule. We ask for an unfavorable report.
Thank you very much. Questions from the committee? All right, seeing none, thank you both very much. All right.
Thank you.
With that, that'll end the hearing for Senate Bill 576. We'll now move on to Senator Reedy with Senate Bill 633.
Chairman, would you mind if I brought up my witness?
Please, yeah, please.
Thank you, Mr. Chairman, members of the committee. Great to be before you on Senate Bill 633. It sounds like it's condominium day in Judicial Proceedings Committee, always one of my favorite days when I was on this committee. Senate Bill 633 is trying to remedy an issue that condominium owners have found allows some owners to not properly maintain their residence and things inside their residence, and as a result place a financial burden on the owners of the entire building. The Maryland condo law as it currently exists places an undue burden upon condominium communities at large, even though Section 11-108.1 states that owners are responsible for the maintenance, repair, and replacement of within their own unit. There are really no consequences for those who choose not to maintain and repair appliances, hot water heaters, plumbing, or toilets, etc. So when a resident does, unfortunately, at times neglect that responsibility, and there's an insurance event caused by that neglect, so for example, a hot water heater failing or a improper leak that they don't report and don't take care of, once that owner of that individual unit has paid their deductible, which might be as little as $250 or $500, their insurance policy pays the next $10,000, and then the balance is the responsibility of the community at large. It's in that's found in Section 11-114, which is required insurance coverage reconstruction. It's on page 37. In an example provided by one of my constituents, and I believe she's here today with me. I think this was your example. A resident with a 14-year-old water heater refused numerous times to replace a leaking water heater, even though it had exceeded the 10-year standard length. Neighbors on the first and second floor below saw water damage in their units and informed the property management company or the property manager. It was clear neglect on the part of the resident, but the resident's only responsible for the deductible and the insurance coverage of $10,000. In this particular condo association over the last number of years, there have been events like this that cost anywhere from $30,000 to almost $50,000 to repair the damage. And in this particular case, it's a relatively small condominium association. It's not a large one, but this is a problem with large ones as well. So for a $1,500 to $2,000 hot water heater, the cost of the community is much greater. So the Maryland condo law does not distinguish between events that are not the fault of a resident, obviously, as some sort of storm or other type of maybe condominium-wide, building-wide failure versus ones that are irresponsible or neglect from the resident. Unfortunately, this particular condo association, and this has happened, I've heard from multiple ones where their insurance company is canceling their coverages now because of these kinds of events that keep happening. And so, for example, this one condominium association, the annual premium went from $53,000 with a $10,000 deductible to $200,000 with a $50,000 deductible with Lloyd's of London, which is as probably a lot of you know, is a last resort insurer. And so this particular association consists of only 152 units. Vast majority are seniors. And I think I've been hearing from others in this space, this is an issue in multiple condominium associations are finding. So there's some more information in my testimony just about the premiums and how it works with someone like Lloyd's, with an entity like Lloyd's of London. But suffice to say, it's significant burden on not just the association, but obviously the individual condo owners, even though most condo owners are doing what they're supposed to do to take care of their particular unit. So this bill would require that if any type of an event is clearly the responsibility of the resident due to non-maintenance or replacement in their units, their insurance company should be responsible for the total cost of repair, not the condominium community association. So I'd respectfully request a favorable report on Senate Bill 633. In a moment, I'll turn it over to my constituent, my witness, who's here to share a little bit of the story. I do understand I've been approached by folks that are interested in talking about this issue that right now might be opposed to, but are looking at amendments to a couple of concerns they have about insurance premiums and rates. So open to those conversations. I think this is something, I think there's maybe a couple of other bills in that are similar to mine. Just trying to get a handle on this so that we can make sure that people bear responsibility for what they're supposed to be responsible for and keep this a reasonable insurance cost for these condo associations. And again, particularly a lot of them in my community are not, 3,000 units. They're small associations. So with that, Mr. Chairman, I'd like to have my witness speak, and then I'd be happy, of course, to take questions.
Good afternoon, everybody. Thank you for this opportunity. Senator Reedy has addressed, my name is Brenda Freed, and I am a vice president of the Winterford Manor Condo Association. Senator Reedy has addressed a number of the issues that I've brought to him, and what we find is that there are residents that have water heaters that are 20, 25 years old, and you cannot tell whether something's rusted out from the outside, it's only from the inside. So we had a recent event where it was a 14-year-old water heater and the expansion tank was leaking. And the owner was just mopping up water for days, not realizing there was a problem until the people on the floors below her went to the property manager with damage that came down through their units. So with cost increasing, and we're in a 55-plus community, we've also had meetings with other communities that in our surrounding area, in the Eldersburg area, and this is a problem that just comes up in the vast. We just had an event actually this morning. I got an email, and it's a non-unit event, which we're going to take care of. But the vast majority are all people that are not repairing or replacing their units, whether it's a toilet, whether it's a disposal or a washing machine or a hot water heater. And all of this is falling on the community with the people that are mostly on fixed incomes. So revising the law will put the responsibility back where it belongs, and that's on the unit owner to take responsibility to replace, repair, and upkeep all of the appliances within their unit. So I thank you for your time and just relieving the financial burden that is currently placed on the communities that is really going to bankrupt us. Thank you.
All right, so I think Senator McKay has a similar bill, I think, so we'll work on it. But all right, with that, that'll conclude the testimony for the proponents' bill. We'll now switch to the opposition panel. Jenny Hyatt, Jenny Pullhouse, and Robin, come on up. Minogue, and then Scott as well. You're 2 and 2.
Who would you like to go first?
Doesn't matter. Whoever would like to go first. You and Mr. Silverman can go first.
Hi, thank you. Let the record show Robin Manoogian for CAI Maryland LAC. So yes, Senator McKay and CAI are working on a similar bill, but very different at the same time. So right now, when there is a loss in the unit owner pays the master policy deductible not to exceed $10,000. With the rate of insurance, the rate of deductibles going up, we are looking to increase that to $25,000. The bill before you, however, is fraught with problems. So the way the bill is written, the unit owner in whose unit a loss originates would be responsible for the portion of damage they cause, or that can also mean the entirety of the loss. So let's say that someone's smoking, they cause a fire, they burn down a $10 million building. This would make that owner responsible for the entire $10 million of damage. There is no commercial product available in the market right now that will address the requirements of this bill. So I understand the frustration. I've been an insurance agent for 32 years. When losses happen because someone fails to maintain, they pay the first $10,000 of the deductible, and then master policy insurance takes over. That is how the insurance is written. We cover the units as the developer originally conveyed them, and then insurance takes over. but there is simply no product available in the marketplace right now that would take the responsibility of all of the damage covering that a unit owner might make. That is why we are looking to increase deductible responsibility so that when those owners fail to maintain and a loss originates in the unit, yes, they are taking some level of participation in the loss, but they are not taking full responsibility. That's why people buy into condominiums.
Meet again.
Go ahead. Oh, no, wait a minute.
Oh, no, go ahead.
It'll be real quick.
No.
Once again, members of the committee, thank you very much for the opportunity. Scott Silverman for the Maryland LAC. I tell my clients all the time that condominiums are like businesses in which you are a partner with people you did not choose as your fellow partners. So you're running a business with people that you did not select. For that reason, there needs to be common sense legislation that balances the interest between the individual and the whole. While the senator's bill is admirable with respect to its philosophical intent to hold unit owners responsible, it goes too far. Senator McKay's bill, which we hope will be reconciled with Delegate Holmes' bill in the House, which is its cross-file, represents that fair balance between the unit owner's responsibility and the condominium's responsibility. And for that reason, we are working closely with him to get that bill moved forward and would respectfully request an unfavorable report on the instant Bill 633. Thank you. Any questions?
Good afternoon again. My name's Jean Hyatt. I'm owner at Cross Keys. I find myself in uncharted territory because I 100% totally agree with my colleagues at CAI, which is an unusual position. This, no offense to Senator Reedy, this bill is without a doubt the scariest that I have seen come from Annapolis in the past few years directed at condo owners. What it basically is like asking someone to get into a car with no brakes and take your chances, and you will pay for any damage because you are saying your liability will be unlimited. How do you insure for unlimited liability? Let's just say, for example, somebody goes away for a few weeks. They don't know their refrigerator is leaking, and it leaks, and it causes damage to 4 units below. It could easily be $250,000, $500,000 worth of damage, and the owner would have to come up with it. This would bankrupt condo owners looking into the future. I can't imagine that anybody would buy a condo under these circumstances. And I've looked into insurance, and it would be exorbitantly expensive if you could get it to cover $500,000 or $1 million more. So I respectfully urge that we oppose this bill, even though I understand the problem, and I'm hoping some reconciliation between the problems of the whole community and the problems of an individual can be found, but I don't believe this bill is the right way to do it. Thank you very much.
Once again, good afternoon, Chairman Smith and Vice Chairman Waldstreicher. My name is Jeannie Polhouse, and I am a condo owner in Baltimore City. I'm here to testify unfavorably on Senate Bill 633. Senator Reedy has joined with the insurance industry to add additional expense to condo owners across the state of Maryland. In the many years I have lived in my condo, there has been one incident of multiple condo damage in our community. The condo association and the 2 condo owners' insurance companies determined responsibility, and the issues were resolved cost effectively. Maryland's population is aging faster than the national average, and many of these seniors that are living on fixed incomes own condominiums. Condominium ownership makes makes up approximately 30% of Maryland's housing stock. Senate Bill 633 would require condo owners to purchase additional insurance to cover a possible but not probable catastrophic event. And at what level? The bill does not differentiate between units such as mine, a 2.5-story unit built all of concrete with concrete between the floors with no interior common areas, versus a 9-story unit with numerous interior common spaces. Today, many condo claims are under $10,000 and most are under $25,000. Raising the condo deductible to $25,000 would mean most condo owners would pay higher premiums and would not use their insurance coverage, a gift to insurance companies. And then adding another policy on top of that to protect them from certain parts of the deductible is even more. This bill, making the liability unended, is just impossible. This new insurance requirement would price many seniors out of their homes and negatively affect Maryland's substantial condo market. Do not give the insurance industry another gift when the situation is already under control. Do not dictate an unnecessary cost to your constituents. Remember, this is an election year and seniors vote. Insurance companies do not vote. We will be voting en masse this year. Thank you.
Thank you so much for your testimony. Questions for this banner? Senator James.
Thank you all. I don't know if Senator Reedy's still here. Thank all of you. And I noticed that in Senator Reedy's testimony, I think the goal, what he wants to try to deal with is unit owners not maintaining their property. So since you all are opposed, and I understand why, I do insurance law. So really briefly, what can we do, if anything, to enhance the situation where owners are not, and maybe even the condominium association have tried various things, but are there meaningful things that we can do at the state level that would give tools to condominium associations to get these unit owners either up to snuff or out the door or something, short of this, which I completely understand that why this isn't workable and it's not affordable, and there's no product you can buy there's no product that exists that you can buy for this. All right.
So Maryland already has a very broad right of entry into the units.
Right.
When the board can identify, so
The proponent's testimony was that there were water heaters that started failing at a certain age. We know at a certain point the lifespan of components within the unit.
Right.
So when the board can identify that, look, we were built in such and such a year, we're approaching 10 years on these water heaters, it's time to have them inspected. I think that you can have more oversight of components without, I often hear boards say, well, there's nothing we can do about it. There's absolutely something you can do about it.
Well, is it something, I'm trying to think, again, this would be board stepping up, but legislatively, I mean, would it be possible for us to do something that said, hey, condominiums, you have an obligation to, all unit owners are going to have to tell you the date they purchased, the maintenance they're doing, that they're responsible for, and then add some real heft to violating this, because what you're trying to do is prevent catastrophic maintenance failures, like ones that are not visible, by doing that proactive maintenance. You're saying associations can certainly do this, but perhaps we could strengthen that so that we really make people accountable, because I think that's what Senator Reedy really wants to do, is make people accountable for being good stewards of their property in a collective. And there are laggards inside it, right? Whatever the word is.
Yeah, thank you for the question. I agree that with my colleague, but I would say legislatively, if the General Assembly could broaden the provisions of, for example, 11-125 of the Condo Act.
Say that again, 125.
11-125.
Okay.
Where the right of entry appears.
All right.
Its language suggests that it should be exercised only in case of emergency, and with respect to inspection and repair, it doesn't necessarily authorize upgrades of functioning appliances, which may correct,
yes,
which may be reaching the end of their useful life. So, and I actually said this across the street in Economic Matters last week. there are two different ways to manage the risk between the unit owner and the condo. Either we can use insurance as a vehicle, which is what we're talking about here, or we can use proactive maintenance as a vehicle. And if the legislature would make proactive maintenance easier to accomplish by broadening those powers, then we could do it that way. And then the unit owners would still be responsible for the upgrades, but it would prevent the catastrophic water events that we see when water heaters fail and plumbing fails and things like that.
That was great. Thank you for being helpful, too, in trying to come with some way to improve this. Thank you, Mr. Chairman.
Thank you, Senator. Any further questions for this panel? All right, seeing no further questions, that concludes the hearing.
Thank you. Thank you.
For this bill, we'll now move on to Charles County Senator Ellis with Senate Bill 573.
I couldn't even see you. I raised my hand for you.
Good afternoon, JPR Committee, Vice Chair Waldstreicher. I'm Senator Arthur Ellis, District 28, Charles County, here to present a Charles County Senator's Bill. Now, some of you might ask, Charles County Senators, wait a minute, I thought it was just you, Ellis. Well, I have 85% of the county in my district, and our brand new senator, Senator Harris, represents the other portion. So together we make the Charles County Senators. I know Senator Sitton, you were always wondering about that, so I wanted to answer it before it was asked. So this bill talks about common ownership communities, board of governors, the individuals who operate these boards. We have quite a few of them in Charles County, common ownership communities. We have members who have other jobs outside of real estate, outside of the law, serving on these boards. And they really do not know a lot of the applicable laws and practices of the HOA and condo associations. So therefore, Senate Bill 573 will set deadlines to complete training and provide parameters for the types of training curricula that can be satisfied based on this bill. The deadlines are fair, with members having 90 days to complete the training and to only renew their training every 3 years thereafter. Individuals who do not complete the training may be removed from their position or unable to vote on affairs of the governing body. We select organizations, national organizations of condos or community associations, HOAs, to provide the training. It is out there available for individuals. And so we believe that upon passage of this bill, individuals going through training on the rules of the road will basically be able to function so much better to create more harmonious communities. Because so many individuals, they move into these communities not understanding that they have to pay monthly or quarterly fees, dues. Unfortunately, quite a few real estate agents do not tell them those fees are due on a regular basis. And quite often, if you go into a new community where the builder controls the HOA or the condo, they subsidize a lot of the services for the community, and the ingoing rate that the HOA members have to pay is very, very low, because those services for trash collection, for lights in the community, to provide landscaping, and of course snow removal on the streets are all on the backs of the HOA. So if the builder controls before they turn over the community association to the owners, they subsidize this. They keep the rates low, and the homeowners have a false view of the total cost. So when the builders pull out, the owners have this increase in HOA condo fees, and a lot of resistance developed. So if individuals are trained about this, they will know what to expect, and they will not basically accuse their fellow members who are presidents and officers of these boards of malfeasance or worse. And so basically, education is key to a peaceful community. Therefore, colleagues, I urge a favorable vote on Senate Bill 573.
Thank you. Senator Ellis, Senator West, and then Senator James.
Thank you, Mr. Chair. Senator Ellis.
Yes, sir.
I've been looking through the bill to try to find some information about the nature of this training, or the time that the training would take.
Yeah.
I can't find anything in the bill which would indicate, all it says is complete a training curriculum. It doesn't say a 4-hour, 15-hour, 3-week, 2-month. It doesn't say what the training curriculum shall consist of. Am I missing something?
No, you're not, because I was looking through the bill, and like, wait a minute, I said to my assistant, I said, wait a minute, there's no time frame in here. So I think we would have to submit amendments to require, say, 4-hour training, so I'm willing to do that.
Yeah, if you could get some amendments, I think it would be
I believe.
helpful, because just training could be 20 minutes, you know?
Yes, yes.
So
I'll
for it to
basically
be meaningful, it ought to be an appropriate amount of time and should cover appropriate subjects.
Yes. And so what I'll do is I'll speak to the county commissioners. This bill came up through the county commissioner process, and I will have them submit a recommended hours of training and speaking to the advocates, and then I'll submit that amendment to the committee.
Thank you.
But thank you for picking that up, Senator.
Sure.
Thank you. Senator James.
Oh, thank you, Senator Ellis. Very clear presentation. I too was trying to look through the bill to understand not the intent, which I get, but the mechanism, like how would you accomplish this? I noticed in the fiscal note, it says this is under local expenditure. Although a local common ownership commission recognized by a local government or the state is an authorized provider of the training, so presumably some counties have this organization and they are authorized to provide the training, Charles County is not explicitly required to develop or administer any training under the bill through the county's, I guess, existing homeowners association dispute resolution board. All right, and then however, if the county were to go forward and perhaps not use the resolution board, they estimate it would be about $50,000 a year. So I guess my thought is that it seems that fiscal note seems to hint at a way to amend the bill, which would be to, have it go through, if this is correct, if this homeowners association dispute resolution board that exists in Charles County, it sounds like the fiscal note is saying they are an authorized provider of this training as they exist in other counties. So I'm suggesting maybe you talk to Charles County or whoever you like, but just to see if that might be what you would want to do to clarify, as my good friend, the senator from Baltimore County said, it's a little unclear. And then last thing I want to ask, is Charles County, assuming they agree to work with you on that, will they send a letter of support? Because it looks like some of the expense is going to be on them to either use this existing resource or develop a new one.
Thank you for that, Senator James. So this is their recommendation. We go through a process in Charles County with delegation early on in September. We have these public hearings and people present their ideas for legislation, and the county commissioners present their ideas also. And then the commissioners take the recommendations back and they vote on them. So this bill was voted, I think unanimously by the county commissioners for us to present to the General Assembly.
And then,
yes.
yeah, and I don't need to cut you off.
No, go ahead.
I know we're trying to keep these hearings short, and I don't want you to be short shrifted, so, but I want to just make sure. That would be great if you would share that, and then it would be helpful to the committee if you could let us know, if that section, which is in writing, maybe you could let us know if you and Charles County want to go through that existing system and then put that in the bill.
We will do, and we will connect with them today.
I didn't say today.
No,
thank
today.
You.
We will.
All right.
Thank you so much,
Thank
Senator
you so
James.
much.
Great. Seeing no further questions, thank you, Senator Ellis, for joining us here at
Thank you, Vice Chair.
JPR. Give our best to the minority leader, who I know is in town today, and we'll see you soon. That concludes the hearing on Senate Bill 573. We'll now move to Senate Bill 481, Senator McKay, and then afterwards your bill, Senate Bill 484.
Yeah, it doesn't. It's up to you. Now we're going to sit on the list. Just kidding. Go ahead. Okay. Thank you, Mr. Chair. Thank you, members of the committee. Thank you for the opportunity to present Senate Bill 481. Time taken, time back. This bill purpose is to shift on how Maryland courts handle the unjustifiable denial of visitation, moving from a discretionary approach to a mandatory requirement to make up time. If a court finds that a party has unjustifiably interfered with visitation, the court shall, rather than may, order additional periods of visitation. Another key objective is to double the duration. Now, Senate Bill 481 requires that additional visitation time must be doubled the duration of the time that was originally denied or interfered with. This matches up the visitation type. To reschedule the time, it must be the same type of lost visitation specified, naming weekends, holidays, and summer visitations. The party whose rights were violated is granted the authority to choose the time for the additional visitation. The time frame for compliance, these additional periods must be scheduled within 2 years of the court's determination. At the end of the day, this bill is a protective standards and remedies. We believe that this bill is what's in the best interest of the child, that all court orders for additional visitations must remain consistent with the best interest. Also, while the makeup time becomes mandatory, the court still retains the discretionary power to modify the customary orders to include terms of enduring future compliance. It also, the excess court costs and counsel fees against the party who interfered with the visitation. And if I may, the core of this bill is about fairness to both the children and the parent. Both parties want to do what's right for the child, but unfortunately, the sin nature kicks in, and we need to be able to have parity and fairness. And so that's what this bill is about. Just ask you that time taken should be time given back. And with that, I'd like my panelists to be able to speak and answer any questions that you may have afterwards. Would you come on, stand up here.
Good afternoon. Good afternoon, Chair, Vice Chair, and members of the committee. Thank you for your service and the opportunity to speak today. My name is Brian Fitzgerald. I'm a father, and like everyone here, I am also someone's child. There's one truth that crosses every party and every belief. Every child understands love as time. Not legal language, not explanations, just time. When a court issues a visitation order, adults see it as a schedule, but to a child it feels like a promise. You matter and your time with both parents is protected. The problem this bill solves is simple. when that court-ordered time is taken from a child and nothing restores it, the system teaches the child that promises made to them can disappear. While adults wait for hearings and motions, children don't understand procedure. They ask themselves, did I do something wrong? Am I the reason they're gone? Time taken, time back is built on a simple child-focused principle. When time is taken from a child, that time belongs to the child and should be restored. This bill makes court orders meaningful, provides a practical remedy for judges, and protects children from the emotional cost of lost time. I respectfully urge your favorable consideration for time taken, time back for every child in Maryland whose time deserves protection. Thank you.
Thank you, sir. Let's take our virtual testimony and then we'll have questions. We'll go first to Christina Relo. Christina, you can unmute yourself and then you're good to go.
Good afternoon. Can you hear me okay?
Yes.
Okay.
Yes, we can. Go ahead.
Good afternoon, Chairman and members of the committee. Thank you for the opportunity to share my testimony with you today on behalf of countless families in my state who have adversely been impacted by unsubstantiated unilateral withholding and child custody interference. My name is Christina Rilo. I am a Baltimore County resident and state of Maryland employee with joint, legal, and physical custody of my 4 children. I'm here today in support of SB 0481 based on the positive outcome that my children have experienced, resultant of a similar plan of action being implemented at my modification of custody settlement hearing. I've had experience with family court over the past 10 years, successfully seeking their assistance in matters pertaining to my divorce, contempt filing, and most recently for modification of custody. To protect my parental rights, I resorted to funding these efforts by means of a home equity loan. In 2016, when I initially filed for divorce, I chose to file for joint legal and physical custody, motivated by my belief that it would be in my children's best interest for them to be able to maintain and cultivate quality relationships with both of their parents, regardless of our individual differences. While court-ordered custody schedules are expected to be adhered to, parents are also expected to successfully collaborate for deviations as needed. When collaborative efforts are unsuccessful, it becomes apparent just how few supports are in place for rule followers and survivors, and appallingly how few consequences are in place for abusers. Ultimately, the ones who pay the greatest price are our children. SB 0481 presents a solution to ensure restoration of the parent-child bond following unsubstantiated unilateral withholding, while simultaneously disempowering an abuser's efforts to intentionally damage a child's bond with their equally fit, willing, and able parent. I thank you for your time today, and I humbly seek your consideration in support of this bill in light of my testimony.
Thank you so much. We'll now go to Mr. Garza. Mr. Garza, unmute yourself, please, and go ahead.
Thank you, Chair, Vice Chair, and members of the committee. My name is Robert Garza. I actually went through 43 false allegations, and when this actual bill passed in Texas, it passed unanimous, bipartisan, the first time, and the governor signed off on it. When I went through 43 false allegations, it took me $700,000 just to be able to be a fit, willing, and able parent in my children's life, and 16 years in family court. When my ex did all these games and did all these false allegations, as soon as this bill came out and made law, there were no more false allegations. The game stopped. This is a very powerful bill because if people know they're going to weaponize the system, and they are weaponizing the system, they weaponize family court, they weaponize CPS against you, they weaponize pretty much anything they can do. And when this bill is in place, they know that whenever they return the child, they shall return the time. And in doing so, it repairs that parental bond that was broken in the process. It's a big deal. It's enough of a big deal right now that if you withhold a child against a court order, it is a felony in your state. But yet you bring it into family court and it's a slap on the hand. When this bill passes, the courts will make a very clear message that you can't just withhold a child without any a protective order or restraining order. Now you can go get, if there's domestic violence, 100%. go get a protective order, restraining order. It automatically overrides any court order in your state, and nobody gets in trouble. That's not what this bill does. This bill protects false allegations. Thank you for your time.
Thank you so much for joining us. Questions for any of our witnesses or our sponsor on this legislation? Senator West.
Thank you, Mr. Chair. I do have a question for the sponsor, if I could. Senator, I'm looking at the existing law. Unfortunately, this law is really quite brief. The beginning language, which would apply not only currently applies, but also would apply if your bill's passed, says, in any custody visitation proceeding, if a court determines that the party to a custody or visitation has unjustifiably denied or interfered with visitation granted by a custody or visitation order. So the court has found that a party has unjustifiably failed to comply with the court's order. And then under the existing law, once the court has made that finding, it says the court may order the visitation be rescheduled, modify the custody or visitation order to require additional terms or conditions designed to ensure future compliance, or assess costs or counsel fees against the party who has unjustifiably denied or interfered with visitation rights. Sounds pretty draconian to me. So, but what your bill does is say the same court which I think you believe is not ordering these things, having found the same unjustifiable interference, now under your bill shall order additional periods of visitation and double the duration. I guess my question is, since you're talking about the same court with the same predicate finding that there was an unjustifiable denial of or violation of the court's previous order, why do you think that a court, having found that, would be more likely to, why is the court currently unjustifiably not granting the additional visitation time under the current language of the statute, which you think would be remedied by your replacement language? We're talking about the same court.
So yes.
So I'm a judge, and I've made a finding.
Correct.
That the person who's the subject of my order has unjustifiably violated my order, and I have the current remedies available to me. If I'm a judge, I'm going to avail myself of one or more of these remedies to solve this problem, because the person is in contempt. They've contemptuously failed to follow my order as a judge. So I'm not sure what your bill adds to it. Maybe you could give me.
I think it just adds the deterrent.
Word shall?
It adds that the deterrent is placed, and so that I think at the end of the day, what we are trying to do, and I don't know if this answers it exactly, sir, is that we are trying to deter that families are using the child as a weapon back and forth. So if we can determine...
I completely understand that. There's no question, and some families do.
Right.
But if I'm a judge, I'm an impartial arbiter sitting on the bench, and I have made a finding that one of the parties has unjustifiably violated my order and therefore is in contempt of court for violating my order. I'm certainly, if I'm the judge, I'm going to avail myself of one or more of the options that are in the existing law. I'm not going to say, oh, well, never mind. If someone violates my order, I'm going to go after them and make sure that my order in the future is observed.
Well, I think it all tells on mandatory, and that it automatically makes sure that this happens. And so therefore, any of the false accusations at the beginning know that there is a possibility that if you try to take away time away in the original agreement, that actually is going to be used against, not used against you, but you'll actually have double the time to pay back that time that's left.
Okay, well, let me just pursue this one more question. So it sounds as if the reason for this bill is because some judges are finding that people have violated their orders and are in contempt of court, but are failing to avail themselves of the remedies provided in the law. And that's why you want a bill which requires them to do certain things by using the word shall. So are we really talking about a lot of judges who have concluded that that people in front of them have violated their orders and are in contempt of court, and the judges are really doing nothing to enforce the orders that they have previously promulgated? Is that the premise of this bill?
I think what the premise of the bill, as my witness has testified to, that time is what equals love from the child, from the parent. And when the court system is trying to do what's right, but at the end of the day, we are hurting the relationship between the child and the parent. And unfortunately, as the witnesses on Zoom and that kind of stuff has said, it has been as weaponized. And so you will see some opposition from the judiciary on this, but I tend to believe that if we're going to put the child as the number one person in this, we've got to be able to put some constraints and yes, put mandatory to help this situation. Because at the end of the day, the child doesn't understand why dad or mom is no longer in their life. They don't understand the court order. They don't understand what the judge. And being a non-lawyer on this particular committee, there's a lot of things you guys talk about that I have no idea.
Let's go to.
So I could be in the same position as that child to not understand. And so therefore, without not having the time that they're supposed to be having with both sets of parents, I just believe that this bill is putting the child first.
I got it.
And therefore requires the mandatory.
I really appreciate your answers. Thank you.
Thank you. We'll go to Senator James and then Senator Charles.
Thank you so much, Senator. Unusually, even though my career is similar to Senator West, and I worked in large law firms, mainly corporate and defense issues, we had a subspecialty with a group of us, 2 or 3 of us, who did domestic work. And I was good at it enough that I kept doing it, even if that wasn't always what I wanted to do. So I had some experience here. So, and I absolutely appreciate the witnesses with the frustrations that go on when parents are divorcing and custody is an issue and visitation is an issue, and one side or the other or both sometimes are not being fair, respectful, and are quite frankly being selfish, and the children are often caught in the middle and they're way too young and really. So I didn't grow my business because I would tell any client who wanted me to do something that to me was counterproductive for the child that I wasn't the right lawyer for them. But let me get to this. I think the substantive issue that I'm struggling with is, I think Senator West made it clear, and I know you're not a lawyer, but we would not tell you this if it were not true. Courts can already do this. Whether they would double it, I don't know. They certainly have that vested authority, but they go through a hearing. But here's where I think the court, they may be falling down, and I would love to work with you because there may be a bill in which we press the judiciary for, instead of mandating this, we press them with some other ideas that I have to get them to be far quicker, responsive, and whatnot. We also have to help fund them. But here's where the issue comes. When you have a blanket, okay, we're going to double the time. The child, this applies to every child from infancy to their emancipation. And each child along the way may have a multitude of other things they do. And the visitation and custody are wrapped into where parents live and all this. So unfortunately, as much as I applaud what you're trying to do, and I'm very sympathetic to the people that testified, if this would probably be counterproductive in an awful lot of cases, because it then would smack up against maybe creating all kinds of problems for the child, and it's always the best interest of the child, to be able to go to a certain activity. I can't explain all the complexities, but I've dealt with them, all of them, and I can give you anecdote after anecdote. So I'm very sympathetic, but I think what the witnesses are missing is the court does have this authority, Senator. The question is, are they using it vigilantly and fairly in the right cases, right? And if not, we have people that feel that way, and we've got to work through that. So I throw that out there and hope that you'll work with us and work with me with some experience in this, if this bill or other things to facilitate the judiciary being as sensitive as they should be.
Right. Well, I think to answer that was one of your normal questions that for a lot of bills is, where is the data? Where does the data show?
Right.
And so we can reach out and try to figure out from the Texas law or different other places to see where this is actually shown.
And I'd be very interested.
So that, I think that would be there. Do you want to add anything to that? No? Okay.
All right, Senator Charles.
Thank you.
Thank you, Senator.
Senator, this is a really good bill. And I was listening to Senator West and his question, and I just wanted to make it clear for you, and you can just say, isn't it so? The current law it says the court may, right? And so it may add remedies. Your bill is coming in, like Senator West mentioned, says that they shall add remedies. And to our other senator, with her comment on the bill in terms of different activities bumping up against, it looks like when I read the fiscal note, it's matching the time. So if you're every other weekend parent and they wouldn't let you get, the other parent didn't let you get your weekend, you wouldn't get a whole week. You'll get every other week, the other weekends following up to match the time that you were getting. So it won't have any issue with the current custody arrangement.
And yes, that is so, sir.
Thank you.
All right, seeing no questions, thank you for bringing the bill. We'll move to the opponents now. Ms. Ruth and Ms. Smith for Senate Bill 481.
Good afternoon, Vice Chair. It's so nice to see you and esteemed members of the committee. My name is Michelle Smith. I'm here on behalf of the Maryland State Bar Association Family Law Section. I have prepared remarks, but really I'm just going to dive in and say to Senator James and Senator West, we are aligned with your questions. Our testimony reflects the questions that you've asked and the concerns that you've raised. Really, this is an issue that I'm not sure the state of Maryland is grappling with. I didn't hear, with all due respect to the proponents that did testify, I didn't hear any testimony about specific cases in which this has become a problem. Now, I'm not a Pollyanna. I do this work every day. Just like Senator James said, we know that there are issues. We know that certain cases, maybe we would disagree with the result, okay? But the court already has this power. The court exercises this power in cases every day. It is not in keeping with our case law or now our statute regarding the factors that a court must consider when determining what's in the best interest of Maryland children to dictate to the court that in every single case, breastfeeding baby all the way up to 17-year-old child should have double the time. I would suggest that it is not a deterrent because it is not automatic. The judge still, as Senator West pointed out, has to make a determination after a hearing. There's still a waiting process. It is not an automatic deterrent. And therefore, for all of those reasons, we'd ask you to stay focused on what's in the best interest of Maryland children and give an unfavorable report to Senate Bill 481. Thank you.
Good afternoon, Mr. Vice Chair, members of the committee. My name is Laurie Ruth. I'm the Public Policy Director at the Maryland Network Against Domestic Violence. I agree with everything Ms. Smith said, and I appreciate the questions from Senator West and Senator James. We are also in strong opposition to this bill. I think the proponents with whom I have spoken outside the hearing room are somewhat naive about how they think this will actually deter people. But my biggest concern is how it can be abused by abusers. So, you know, I gave a hypothetical to the House, and I'll quickly give it to you. I've got 20 more behind this one. But this bill gives the power, if the court finds unjustifiable withholding, to the abuser to pick whatever time they want for their double time. So setting aside that double time is not necessarily in the best interest of the children for every child in every case, you know, we don't like cookie cutter decisions in family law cases. We like the court to look at each one individually and see what that particular child needs. A breastfeeding child maybe shouldn't be away from a parent for that long, whereas a high school student may be able to, or they may have more activities and not want to go for double the time. But in my hypothetical, my child comes back from the other parent and says, my stepmother locks me in my bedroom, I don't get enough food to eat, I'm hungry and uncomfortable there. And I, a protective parent, say, I can't send my child in their next alternating weekend, and while I figure out what to do and talk to my lawyer and try and make a decision. So I withhold the child. And so the opposing party brings a contempt action against me. I go to court, and because I am likely self-represented and not a lawyer, I am not able to articulate why I withheld that time. All of that conversation with my child is hearsay. It doesn't come in as evidence. So the court says it was unjustified. You get, sir, you get double time. And he knows that I'm getting married on June 15th, and so he immediately says, I want the child from June 14th to June 17th, even though I've already bought the flower dress for my 5-year-old daughter, even though she knows she's going to be in the wedding, and that's it. And that is a power and control dynamic that happens in these cases all the time. So I have a lot more to say, but for those reasons, we strongly urge an unfavorable report.
Senator James has a question.
Ms. Smith from the bar, thank you so much for coming. Thank you for your testimony. You can do this afterwards, but I would love to follow up with you about where you do see some issues, because I probably seen them too, and whether or not more broadly or even specifically we could think about some ways, maybe in this bill or something in the future, to have the judges, and there's a lot of complexity here, I want to lay it on that, have the judiciary and the communities they serve feel better served in an area like this. Absolutely. Thank you.
Great. Senator McKay.
Yeah.
Thank you, Mr. Chair. Please, if I may. So I hear what you're saying, and you ended with power and control. One would say that that exact same argument could be applied from the person just holding somebody back. And this bill, while yes, it is double time, it's really just restoring the time that was taken away from the, quote, power or control position. I really don't understand how it just seems very one-sided that your testimony is not looking out for what is the best interest of the child. The mechanics of the bill are, if it is found that you have withheld, the time that you've withheld is given back. So it's not really doubled. It was withheld.
Senator,
so why does that not matter?
Well, Senator, that's not exactly how I read the bill. I think what you're describing is existing law, as Senator West pointed out. If it's found to be unjustifiable, the court can grant that time back, and they do. I mean, we see it all the time in both directions. I acknowledge that.
Is that data available? So we could actually look at what time the court system has actually given. I tend to believe it's not, because I see a lot of fathers' rights that gets eroded every single day in the state of Maryland. And it just seems to me that while I know we're trying to take care of anybody who is an abuser, I don't want to give them the upper power, but I believe the testimony has said that the judge has the ability to do this. It's just saying that we're going to now give back the time that has already been taken away.
So that's not double time, though. This bill gives them double time. It is punitive, and it's not best interest of the child centered, in my view.
Would you work with me then for it to be exactly the time that was taken away?
I would be willing to discuss it with you. I cannot support allowing the other side to pick the time that they want the makeup time, because I really, really think that that's subject to abuse, and it's an unintended consequence of a well-intentioned bill.
So is your testimony that you're in support with amendments?
I can't right now. I'm happy to talk to you.
Thank you. There again, being somebody who was on the opposite side and seeing a father's rights situation, I don't believe that the testimony today shows that you're trying to do out what's the best for the child. And I'd love to work with you on it, but thank you.
Thank you.
Great. Thank you both. Senator West.
Yes. Could you up there?
Yes.
So I'm listening. Obviously, there's a problem. There have been enough situations in which judges have found the problem but don't grant makeup time that has engendered this bill. So you're a family law lawyer. Here, suppose we were not to pass the bill as written, but amend it to say that the default, in the case the judge finds a problem, that the party has failed to comply with the court order, the default rule would be double time. But the court could, in its discretion, decide not to grant double time, but be required to place an explanation on the record as to why the court deviated from the standard of double time. Was that something you think you might be able to support?
Well, because I have 1,100 people that I have to consult before I answer your question, and by that, I'm not being cute. I just mean I'm not here standing in my own shoes. I'm here on behalf of the family law section. I will ask them, but I think that's a very creative amendment, Senator.
Thank you.
Yes.
Great. Thank you. Seeing no further questions, that concludes the hearing for Senate Bill 481. Senator McKay will then go to your next bill, Senate Bill 484. Senator Charles, I think we're going to take your bill next, if that's okay. So for those listening in the antechamber who are here for Senator Charles's bill, that'll come next.
Excellent. Okay, Mr. Chair, members of the committee, Senate Bill 484. Senate Bill 484 proposes a significant shift in how child abuse and neglect reports are processed in the state. The primary purpose of this bill is to transition from a localized reporting system to a centralized intake system managed by the State Department of Human Services. Now, under current law, reports are made local to local departments of social services or law enforcement. The bill does mandate that all reports of child abuse, neglect, and children of substantial risk or harm are made directly to the Department of Human Services. The department then is required to maintain a state-level centralized system to record and manage all incoming reports. Now, the bill does outline the specific three-step process for the department upon receiving the report. First of all, the report is entered into the new centralized intake system. The department of assess the report for its validity, and then upon the valid reports are assigned to the appropriate local department for the actual investigation. It is true that the bill does strictly require professional mandatory reporters. This could be health practitioners, police officers, educators, et cetera, but does redirect their communications for oral reports must be as soon to the department as possible. Within 48 hours, the written reports have to be submitted, and once assigned to the state, the local department must still meet existing investigational deadlines. When it comes to physical or sexual abuse, the child must be seen within 24 hours of the local department being assigned the case. If case of neglect or mental injury, the child must be seen within 5 days of the assignment, and the overall completion of the investigation should generally be completed within 10 days of the assignment, with a maximum extension of 60 days if necessary. So I tend to believe that this bill opens the conversation There are in opposition the overall, which will be the fiscal note. With that being said, answer any questions that you may have and look for a favorable report for Senate Bill 484.
Thank you, Senator McKay. Any questions for the sponsor on this legislation? Senator James.
I don't want to speculate. I have my own thoughts about how child abuse and neglect is and is not handled in this state, and we've had some catastrophic failures. But your goal here, the problem you want to solve is, and your belief that centralizing it, and everything you just said about your, is the way to do it, is what's the goal and why is this the way to go?
Ultimizing its standardization.
Okay.
And being centrally in a repository mandated by the state.
Is this done elsewhere, and has it shown better accountability, better reporting, and ultimately it's better protection for the child, right? Right?
That's
where
the goal.
you're going.
That is correct.
So does it improve record keeping, the alacrity with which the problem is dealt with, and better outcomes and protections for the children if it's done elsewhere? And if you can follow up.
So
with
I'm going to have to follow up exactly with that.
Okay.
I do believe that the letter of interest that the Department of Human Services has put in the file is valid, and we'll have to work with the department to work around that.
I'm glad you mentioned that. Did you get any pushback from local departments? And if you did, okay, very good. All right, thank you.
We did not. Thank you.
Thank you.
Thank you so much. Seeing no further questions, that concludes the hearing on that bill. Senator Charles, you're up next with Senate Bill 548. Feel free to bring up your panel as you see fit.
Good afternoon, Vice Chair Wald Stryker and the honorable members of the Judicial Proceedings Committee. For the record, I am Senator Nick Charles, and I represent Legislative District 25. And I'm here to testify in support of Senate Bill 548, Family Law, Child Support Determination of Custody, and Agreements Between Parents. Senate Bill 548 does two important things. First, it asks the courts to consider custody and parenting time during pendente lite child support hearings, so child support orders reflect the parenting arrangement temporarily given by the courts until the final hearing takes place. Second, it permits parents, when acting voluntarily and in the best interest of their children, to reach mutual child support agreements subject to judicial review. At its core, this bill is about respecting families, respecting fairness, and recognizing that not every family dispute must immediately become an adversarial courtroom battle. Many parents in Maryland are capable of working together. They love their children, they want stability, they want predictability, and they want the flexibility to craft arrangements that actually fit the realities of their lives, their work schedules, their transportation, their school needs, and financial capacity. Senate Bill 548 does not eliminate the court's authority. Senate Bill 548 does not remove judicial oversight. Senate Bill 548 does, however, simply allow parents, when they are able to reach mutual agreements that serves the best interests of their children. So first, Senate Bill 548 addresses custody matters during pendente lite hearing. One of the most important elements determining child support is time shared, visitation, and custody status. That is in the child support calculator, and you must know that. Today, there are child support hearings that often occur before custody arrangements are established by the courts. And this can create an imbalance if one party to the case keeps the child from the other party going into the child support hearings, automatically and unilaterally making them the sole guardian and provider of the child by default. Senate Bill 548 just asked the courts to rule on both matters during early stages to give a temporary ruling on custody and visitation, allowing the child support to be based on facts presented by both parties. That is truly fairness, and this takes away guesswork. Second part of this bill Senate Bill 548, it addresses the concerns that we must also recognize the practical impact of the recent Maryland Supreme Court decision in the matter of the marriage of Hauser decided in 2025. That decision significantly narrowed the ability of parents to mutually determine child support arrangements without strict adherence to the guidelines, even when both parents agree and even when the agreement reflects the real-world realities of the child. This bill is not an attempt to overturn the court. This bill is an effort by the legislature to restore balance and clarity and clarify the legislative intent so that, one, parents who are acting in good faith are not forced into unnecessary litigation. Two, courts still retain full authority to reject unfair or coerced agreements. And three, families are not stripped of their ability to tailor support arrangements to their unique circumstances. The Hauser decision in 2025 highlighted a gap between statutory language and practical family realities. Senate Bill 548 is the legislature doing what it's constitutionally empowered to do, and that's refining the law so that fairness, flexibility, and the best interests of the children can coexist. Now, despite the necessary intent of this bill, we received 3 letters of opposition from the Maryland Judicial Council of Legislative Committee, the Maryland Network Against Domestic Violence, and the Maryland State Bar Association's Family Law Council. And I want to address those concerns and the issues to you, my colleagues. The Maryland Judicial Council Legislative Committee expressed concerns that the court must remain and retain flexibility and avoid conclusively binding themselves. What I have to say to that is Senate Bill 548 does not remove judicial discretion. It provides structure while still allowing judges to review agreements. Judges already void agreements entered under coercion or not in the best interest of children. The bill does not change that authority. It actually just clarifies and how agreements can be considered. The Maryland Network Against Domestic Violence concern is coercion and power imbalance. Domestic violence is real and must always be taken seriously. But eliminating the ability of parents to agree does not protect victims. Judicial review protects victims. Senate Bill 548 actually creates a moment where allegations can be heard sooner rather than later in comparison to forcing victims into prolonged litigation. The court remains empowered to reject agreements that are unsafe or coerced. The bill does not silence victims. It actually does quite the opposite. It ensures that they are heard and they are heard efficiently. Then we had the Maryland State Bar Association's Family Law Section's position that focused on legal complexity and potential unintended consequences. This is what I have to say to that. Complexity is not a justification for denying families flexibility. Families live with complexity every day. The legal system exists to manage it, not to avoid it. So when families can resolve matters themselves with court oversight, it often results in a couple of things. 1, less litigation. 2, less hostility. 3, faster stability for children. And 4, lower financial burden on parents, our constituents. I also want to acknowledge that the Maryland State Bar Association's Family Law Section participated in the Hauser case through an amicus curiae brief and now appears in opposition to this legislation. It is fair for the legislature to recognize that professional organizations often view policy questions through the lens of their members and their day-to-day practice and professional structure. But when the same community of practitioners participate in shaping the judicial interpretation and then returns to the legislature to advocate that the interpretation remain unchanged, it is appropriate for us as legislators to ask whether we are hearing purely policy perspective or practice-based perspective. This is not an accusation. It's simply acknowledgement that different stakeholders experience the system differently. Families, our constituents, They experience high cost, long times, and emotional strain. The courts, our court system experienced docket management overload, but our attorneys experience procedural complexity and professional responsibility, and of course, billable hours that our constituents have to pay for. Our role as legislators is to weigh all of the perspectives, but ultimately center the interests of children and families who must live with the outcomes. In the brief of amicus curiae, the MSBA says that they represent the 1,000 licensed family attorneys practicing in the state of Maryland. I, however, all of us, we're here to make sure that the millions of Marylanders are not taken advantage of by any system. The Department of Human Service issued a letter of information and raised the concern that allowing custody be considered during a child support proceeding could delay the establishment of child support if there has been no prior judicial custody. Respectfully, I believe DHS concern may conflate pendente lite determination with final custody rulings. Maryland courts already handle cases in which custody and child support are filed simultaneously. In those situations, judges routinely issue pendente lite orders addressing both custody and child support on a temporary basis, so that families are not left without guidance or financial structure while a case proceeds. If courts are already capable of issuing temporary custody and support rulings when both matters are before them, Senate Bill 548 does not introduce a new delay. This bill does not require a final custody determination before support can be ordered. You can do it in a temporary custody evaluation of parenting time and safety concerns, which precisely is what pendente lite proceedings are designed to accomplish. Then we had an additional letter from Maryland Legal Aid, and their testimony is very important. They serve a large group of our constituents who would otherwise represent themselves as pro se litigants and show up to court without private counsel because guess what? They can't afford it. This support that comes from Maryland Legal Aid simply requests that we add some procedural safeguards, and that's not opposition, that's collaboration. I welcome any amendments that ensure agreements are voluntary, that we confirm parents understand their rights, that we preserve judicial review. That strengthens this bill rather than weakening it. They also state in their letter that Senate Bill 548 does not eliminate parents' rights to establish child support through a contested adversarial court process, if that is what they want. And not every child support case can be resolved through consent agreements, and parents may not have valid reasons for seeking different levels of child support. Those cases are well suited for court adjudication. However, the law should not get in the way of parents who are able to resolve matters on their own if that is their choice. Senate Bill 548 will be a welcome addition to Maryland's child support laws because it codifies the ability of co-parents to amicably resolve child support matters, and because non-adversarial conflict resolution promotes healthy co-parenting and may lead parents to spend less time in court, saving our constituents money. And so before I close, I wanted to address this real reality, and it's notable that the Maryland Legal Aid, the organization that provides free legal services to our constituents, they see value in this bill. While the strongest opposition comes from a professional legal association whose members earn income for prolonged litigation impacting constituents financially. If this year for us is all about affordability, that raises a fair public question. Are we protecting Maryland families, or are we protecting antiquated processes that increase billable hours? In closing, Senate Bill 548 is about fairness, it's about flexibility, and it's about family autonomy with some judicial oversight. I respectfully urge a favorable report of this bill, and we will accept thoughtful amendments.
Thank you. We'll move to your panel. I just want to say, separate from the merits of the bill, I've never seen a presentation that you've given as powerful as the one you gave. So, yeah, I really appreciate it. Whoever's next.
Good afternoon. I'm Ami Vora with Maryland Legal Aid, where our attorneys represent low-income parents in child support matters day in and day out throughout the state. We urge a favorable report with amendments on SB 548. Last year, as Senator Charles said, the Maryland Supreme Court ruled that child support must now be addressed in every custody case, regardless of whether either parent is even seeking court-ordered support. So in the wake of this new ruling, there's been some confusion in the courts as to how to proceed when parents jointly state, we don't want child support, or we want child support set at a rate that is lower than what the guidelines recommend. SB 548 attempts to create a path forward here by allowing courts to honor child support agreements that parents jointly believe are in their children's best interests, even if they deviate from the amount prescribed by the guidelines. Parents usually have the most intimate and accurate understanding of their kids' needs, and when two fit parents are on the same page about how to financially support their children, it's our position that the law should trust their judgment and the courts should not interfere. Research actually shows that in Maryland, child support orders that deviate from the guidelines based on the agreement of the parties are actually linked with higher rates of compliance. So we support that this bill empowers parents to resolve financial issues in ways that they think are best for their family, but we do recommend some additional safeguards to ensure that these agreements are entered voluntarily and not coercively. So we really suggest taking a look at California Family Law 4065, which allows courts to honor these types of agreements between parties, but only if the parents declare under oath that they're not being coerced, that they understand their rights, that they understand their alternatives. And further, under that law, if parents later decide that they want to come back to court and get that guideline amount, they can do so, no questions asked, no additional burden. And so there is that safeguard there for them. So with those amendments honoring parental judgment while protecting against coercion, we urge a favorable report.
Good afternoon, Chairman and members of the committee. I'm DeJuan Burton, Deputy Director for Out for Justice, and I support Senate Bill 548, which recognizes the importance of allowing parents to reach agreements without unnecessary court intervention. As a parent who has previously navigated custody and child support negotiations in Texas, I can attest to the value of a system that empowers parents to decide what is best for their children. My co-parent and I went through mediation where we were able to reach agreement on both custody and child support. Our attorneys then formalized that agreement in a Rule 11 document, which was submitted to the court for approval. This process worked for us because it allowed us as parents to make decisions tailored to our child's specific needs without the financial and emotional burden of prolonged litigation. This bill respects the fact that parents are already making these decisions every day, and if we trust them to raise their kids, we should also trust them to determine what is in the best interest of their children when it comes to financial support. We live in a capitalist society where we often see money as the ultimate solution to problems, but when it comes to parenting, financial contributions are only one piece of the puzzle. The reality is that sometimes the financial hardships, such as job loss or unexpected medical issues, can impact a parent's ability to meet court-mandated payments. And when child support enforcement turns into punitive measures, we remove a parent from their child's life and create further instability. This bill, Senate Bill 548, allows parents to establish agreements that reflect their real-life circumstances while still ensuring that, if needed, court intervention remains an option. This bill does not eliminate child support or take away a parent's right to seek legal assistance. It simply acknowledges that when two parents can agree on how to support their children, the court should respect that decision. By passing this bill, we give families the autonomy to create solutions that prioritize the well-being of their children and not just the financial mandates. With that, I urge a favorable report for Senate Bill 548. Thank you.
Christopher Dews, representing the Center for Urban Families. We want to thank Senator Charles for sponsoring this bill. We just want to back up everything that Maryland Legal Aid had stated. And of course, Out for Justice has also stated that we firmly believe that it's in the best interest of the child if the parents already have an agreement and that they're willing to work that out. And even if it deviates from the custody guideline, from the child support guidelines, that if the parents are in agreement and they know what's in the best interest of the child, that we think it's good for the child. With that, simply urge a favorable report and say me too. Thank you.
Great afternoon, Chairman, Vice Chair, and committee. First, let me say a wonderful job for Senator Charles on this presentation. I am David W. Smith Sr. I am the co-founder of the Children's Rights Fund and also the vice president of the 100 Fathers. And working on these matters over the years have seen the definite impact when it comes to the child support and custody alignment. And so I'm just going to hit on a couple points because Senator Charles has definitely outlined what most of us here on this panel agree. And so as we are here today, this is just a little bit of a roadmap, and the legislation is simple and common sense solution that can create an alignment for child custody and child support so that we can create a parallel road that fixes these potholes that have been systematically in error for decades. When it pertains to child custody, or as we fixed in the Child Custody Commission decision-making and parenting time, I call, which most of this is across the board for children and families that support, the problem that support is taking care of the mutual responsibility. Unfortunately, when child support is established first, without establishing the custody, it actually creates a debtor's prison system for those families not in the best interest of children and families. And so I got some statistics here. I shared this last year when we were talking about a bill that under the National Parents Association report card, child custody here in the state of Maryland is still ranked as a D-. Also on the child support report card, they're ranked as a D- as well. And this is facts from the National Parents Association. Also, the Research Policy Research Center just released this report on the $154 billion man. This has shown the impact that fathers are being faced with. So as I end, because I see my time has elapsed,
thank you so much.
I just want you to know that the best child support is the love and support of both parents. Remember that.
Thank you, Mr. Smith. We're going to go to Senator Love and then Senator West. Just to level set here, the judiciary has joined us. They have some bills, but we still have one more bill after this one. And so if there are questions that can be answered offline, please don't hesitate to do that. With that, I'll go to Senator Love.
Thank you, Mr. Chair. Thank you to the sponsor for bringing this bill. In looking at the judiciary's testimony, they said, under current law, courts voir dire the parties about their agreements and ensure the resulting child support order serves the best interest of the child. This allows courts to consider the unique facts and circumstances of each family and each child. So I'm curious what's wrong with that. And then secondarily, while I appreciate legal aid's bringing in California's system, I'm very concerned about the situation where someone is agreeing to something just because of the power and control and the power dynamics and the abusive control that one party is exerting over another one, and that party may be agreeing to something that isn't in their best interest, that isn't in the child's best interest, but because of the situation that they're in. And so the judiciary bringing in their ability to voir dire the parties, I think, is really important. So my question to you is, why is that not enough?
So when the Supreme Court made their decision on the Hauser case, it truly stripped the flexibility away from everyday citizens. The Supreme Court made a decision saying that they are forced to now have child support orders in place when both parties may agree that I may pay the mortgage for you, for your house, and I'll give you this for school. But now the Supreme Court has ruled that you have to pay a child support order based off of this. It took away all flexibility. The one party could actually give more money or more support to help the family and the child once they have separated. But that flexibility being out the window now forces folks to deal with long, litigious outcomes. You got to stay in court, spend more money, and so it becomes a larger problem. I think that is something that we need to address. That's why we push forward with this bill to make an assessment of that ruling. The courts still have the ability to come in and say, this does not make sense, this is not in the best interest of the child, and we believe you should make an adjustment to the child support order. But to immediately force every single parent to actually have to go through this process when they are in agreement, I believe that's where the structural problem comes in. When you take away the flexibility for everyday citizens to do what's in the best interest of their own household. To your other point about coercion and dealing with that, I believe coercion, this happens. It's a negative, nasty problem. The good part is we have good judges who assess these issues. When you're going in front of the courtroom, a lot of those issues that you're talking about with coercion, they're taking place privately amongst folks. But once you get in front of a judge and you're able to express, this person has done X, Y, and Z to me, this is something that happened to my children, this is this, the judges have the discretion to make a determination. And now you have somebody that's right in front of you that can make a judgment ruling on the issue that was brought before them. So I think this puts them in a more protective state than anything, based off of your question.
So, Mr. Chair, if I may. So I'm thinking about a situation where you have a coercive partner and that there is an agreement made outside of the court that is not in the best interest of the child, that is not in the best interests of one of the parents, but because of the power dynamic in that relationship, that one party felt they had to make that agreement, either for their own safety or for their child's safety. So now the parents have come together with a quote-unquote agreement that the court must enforce, when it's actually not at all in the best interest.
The fact that they're in court is typically because it's probably coming out of a divorce settlement. And so they're in front of a judge to address an additional issue on top of the divorce settlement, which is child support. If the person that is in front of a judge saying, I want to get away from this person, filing to get a ruling on divorce, that same person is empowered to say the same exact things about support. And so taking the power away from them to make that own decision for themselves, I think that's an overstep. I think it's a huge overstep, and it takes the power away from the people.
I think we'll take this offline. Thank you, Mr. Chair.
Thank you, Mr. Chair. I just have one question for Mr. Dews. If you would step up to the podium. I've got a hypothetical here. So both parents in a particular situation believe they came up from the streets, and they went to the school of hard knocks, and they toughed it out, and they made it. And they think their child should go through the same experience, should not be coddled, should go through the school of hard knocks, and should make it on his own. And they enter into an agreement which is so restrictive in terms of the provisions made for the child that the judge concludes that this child would be basically reduced to penury. But under this bill, there's a conclusive presumption that the agreement is okay and the court has to approve the agreement. Is that something that your organization can support?
I would say in response to that, as Legal Aid has mentioned, that there is a California statute that I do think would, I know there's some conversations around amendments that I think could strengthen that specific argument. One, I'm hard-pressed to find, and I understand the hypothetical, I am hard-pressed to find an example where I do believe the two parents coming together to establish a child support order or agreement on how much the individual would pay. It is kind of a far sight that they would demand that their children specifically earn very, very little. So I think it's an honest hypothetical. I don't think that that's a circumstance specifically for the Center for Urban Families where we've talked to the countless fathers and mothers that have been in these situations that would normally occur. So it's very hard for me to answer that question directly. I just don't think that would happen realistically. Okay. In the same way I would say, for example, the two parents come together and say, well, we just don't think that the kid should ever have access to transportation or food or anything to that effect. In our experience, we just find that parents tend to, even if they are wrestling with each other, they tend to do what's best in the best interest of their child.
Well, your reference to the California statute suggests to me that you are not wedded to the use of the adjective conclusive in the bill, A conclusive presumption means the court cannot deviate from it. It must accept it. I'm not sure I've ever run into conclusive presumptions in the law before. There may be some, but if there's so, I haven't encountered them. So it sounds like you are also not entirely 100% positive that we should use the word conclusive in the statute.
I would say principally, we are, for the Center for Urban Families, we are 100% in support of parents being able to make those decisions on behalf of their children. And I would pass that over to Ami or anybody else from Legal Aid to also further that question.
Yeah, so let's do one question, one answer.
I apologize.
I think that's been answered. Thank you so much
Chair.
for this panel. We'll now move to the opposition to the bill, Michelle Smith.
Mr. Vice Chair, esteemed members of the committee, hello again. My name is Michelle Smith. I'm here on behalf of the Maryland State Bar Association Family Law Section Council. I'm here to testify and ask you for an unfavorable report on SB 548. I feel the weight of the entire judiciary behind me, so I'm going to make very brief remarks. I would ask you to refer to our written testimony. It is true, Senator Charles, that we did file an amicus brief in the Hauser matter, and I am here on behalf of the Family Law Section Council to continue our same opposition to this legislation because it would allow something that we did not think was in Maryland children's best interests that occurred in the Hauser matter. There have been questions asked here. I would like to respond to those because they align with my testimony. We have a question about the theory of conclusive presumption. I would agree that I myself have never encountered such a presumption in the law before. Maybe I'm mistaken, but I'm not 100% clear what it means. And I think that is a very serious flaw with the bill. I also understand and have had discussions with the legal aid representative that testified, Ms. Foray, about the California amendments that may be addressed in a future version of this bill. I would like for us to be included in that conversation about those amendments. I cannot speak to them now because we don't have them written and I'm not 100% sure of what they would say. But as the bill stands, we ask for an unfavorable report. Basically, the bottom line is that it would allow parents to eviscerate our child support statute. And we have worked very hard for decades to put that statute into place, and we agree that it is in the children's best interest to apply it. Thank you.
Thank you so much. Questions for Ms. Smith? All right, seeing no questions, that concludes the hearing on Senate Bill 548. Thank you, Senator Charles. We're now going to move on to Senate Bill 474. I'm aware that the judiciary is with us. We have a witness on this next bill that needs to leave, so I'm going to take this. Senator Love, do you have a moment?
Okay, our next bill is Senate Bill 474. Senator Waldstreicher, do you have your panel?
I do. Thank you, Madam Chair. This is a bill with which the committee will be familiar, as well as our friends from the judiciary who are joining us here today. The core to this bill is a distinction that it's always good to be reminded of, which is the difference between economic damages and non-economic damages when there's a tort. Economic damages is the cost of putting you back together. It's the medical expenses and the lost wages, everything that can be measured that can best be returned to you. That's the economic damages. The non-economic damages are the things that in life that make life worth living. And I want to kind of build this into a hypothetical to center our conversation today. And so let's say you are walking at a crosswalk. There is a green light above and the white walk sign is on. You're walking with your daughter in the crosswalk. And coming down the road is a drunk driver. They would blow a .20. They're going 85 miles per hour in a 45 mile per hour zone, and they strike you. The economic damages is the cost of the medical expenses to put you back into the situation that you were before the accident, and the lost wages you may have from your time away from work. But let's just give a few examples of what non-economic damages would be in that situation. Let's say in those circumstances that your dominant arm were severed. The medical expenses would be huge, and they would be paid out of economic damages. But there'd be nothing in life more difficult than going around without your dominant hand, without your dominant arm. Think about how that would impact your life each day. Think about how that would impact your functionality of getting ready for work, doing work, interacting with your peers throughout the day, and what that would cause you to feel for the duration of your life without your dominant hand. That's the non-economic damages that you're trying to measure. Or let me give you a better example. Many of you know, I love to eat. And let's say in this hypothetical, my tongue were severed. And medical science can do incredible things, and the economic damages will cover that. Or maybe you need an external food source, or maybe they're able to stitch your tongue back together. But the pleasure of eating after this accident will be gone for the rest of your life. And so the economic damages can put you back together. But the non-economic damages measures what it's like to live without a pleasure that you've always lived with. And of course, there's other examples. In this example, let's say that the person lost their sexual functioning. Same idea. Medical science can do amazing things, and economic damages will pay for those repairs. But you would go through life possibly without continued sexual functioning. That's the non-economic damages side of things. And so as we've had this debate over the past few years, what I struggle with most is this dichotomy where the economic damages, the medical expenses that are fairly straightforward are the ones that are not capped. But the measurement of the things that make life pleasurable, that make life worth living, are capped and are limited. And you're going to hear about that today with a very specific example and from an attorney who has practiced in this area. And with that, Madam Chair, I'll turn it over to my witnesses.
Good afternoon. My name is Kayla Brady, and I am the widow of Jake Mace. Jake died on November 15th, 2019, after his employer, Walmart, sold him a firearm and ammunition on his lunch break, even though they knew that he planned to use the gun to take his life. Jake had a history of mental health struggles and was hospitalized several times for suicidal ideations. In the weeks prior to his death, Walmart management knew this. Jake also sent a text message to one of his coworkers informing her that he planned to buy a gun to kill himself. That coworker sent a screenshot of the text message to a top Walmart manager who said he would take care of it, meaning that he would make sure Jake was not sold a firearm at Walmart. Then tragically, Jake left Walmart after being sold a gun just 6 days after the text message was sent, drove to a nearby parking lot, and used the gun to kill himself. Jake left behind 2 sons, one of which was not even born yet, as I was only 8 months pregnant when Jake died. Myself, along with Jake's mother and father and his children, sued Walmart for damages relating to his death. We filed the case in 2020 and finally got to court just last month after a very emotional 3-week trial in federal court in Greenbelt. The jury awarded our family more than $8 million in non-economic damages. But as a result of Maryland's existing cap on non-economic damages, the jury awarded will be reduced to $1.3 million. My son Grayson was awarded more than $2.4 million in non-economic damages, and that will be reduced to less than $400,000. This is not fair. The jury weighed all of the evidence and made a determination as to what the non-economic damages should be in this case. But due to the cap, we will receive nowhere close to that number. And for all of these reasons, I urge the committee to submit a favorable report on SB 474. Thank you.
Good afternoon, Senator Love, members of the committee. My name is Mike Winkleman. I practice in Prince George's County, and I'm the current president of the Maryland Association for Justice. Walmart made $169.232 billion in corporate profits last year. Due to Maryland's cap, which we seek to eliminate in this bill, Walmart had an additional savings of $6.7 million. And that raises the question, Senators, do we in Maryland truly believe Walmart needs protection under the law more than people like Kayla and her children? We are here because we continue to believe the answer is no, and suggest this form of corporate welfare should come to an end in Maryland. It's not just the Walmarts who are profiting from the cap. As we attached in our written testimony, insurance profits have increased dramatically between 2022 and 2024, from $39 billion to $89 billion to $144 billion. Also noteworthy during this period of time, as included in our written testimony, insurance premiums have increased more than they had in 45 years. And I'd be willing to bet everybody on this committee's insurance premiums increased over that period of time without any change to tort law and with a corresponding rise to corporate profits. There is also, as we referenced in our report, tremendous disparate impact of caps on women, the elderly, children, and minority populations. There are a number of didactic studies which are attached to our reports which show this disparate impact. I would also note that Maryland is the only jurisdiction on the East Coast that has caps, one of only 8 in the country that has caps. None of our neighbors have caps. And I bring this up so that when the opposition says our insurance market will fail, none of our neighbors have failed. We urge a favorable report. Thank you.
Thank you. Ms. Brady, on behalf of the committee, I just want to say we're so sorry for your loss, and thank you so much for coming. It's very difficult to come in front of a room like this and to testify, and we really appreciate your coming. Do members have questions for this panel? Seeing none, thank you all very much. And we will turn to the opposition panel, which I believe is Bob Enton and Carvel Collins.
Thank you very much, Madam Chair. Robert Enton on behalf of the American Property Casualty Insurers Association. Our members write approximately 2/3 of the property casualty insurance in the state of Maryland. I've testified, this will be the 4th year in a row I've testified on this bill against it. This is the 4th year that this bill has been in front of your committee. It did pass out of your committee the second year it came in. The bill went no place in the House, even though what passed out of here had dramatically risen the cap. The other side on this issue decided as they are today, they want absolutely no cap on non-economic damages whatsoever. This is not about Walmart. It's about you. It's about your constituents. It's what is going to happen to their insurance rate. And if you think, tell me, does anyone in this room think that if you take this cap off and all of a sudden you have these multi-million-dollar verdicts, that is not going to increase the cost of insurance? You know, and I know that it will. Secondly, I would say to you that I was able to obtain a copy of the sign-ups for today's bill. And if you look at the sign-up sheet, I know you all have it. If you look at the sign-up sheet, you'll see that 3 people signed up in favor of the bill and 29 different witnesses signed up in opposition to the bill. You should also have a copy of the coalition members that oppose this bill, and they're everybody from Allstate and insurance companies to owner-operated independent drivers, Maryland Transportation and Builders, Maryland Hospital Association. There's tremendous opposition to this. We would urge you not to remove this cap. Thank you.
Thank you, Madam Chair, members of the committee. Carville Collins on behalf of the Maryland Employers for Civil Justice Reform Coalition. We are opposed to the bill, as we have been, and we have discussed this with the committee many times. Just a reminder to the committee why we have caps. They've been an important public policy in Maryland for nearly 40 years. Back when, in the mid-'80s, when the state faced an insurance crisis, there was a study group formed. This committee had a great deal to do with the solution that was developed. The solution was, and this was in the committee report, they needed to assure the availability and sufficiency of liability insurance at a reasonable cost in order to cover claims for personal injury. That history is still applicable today and still is the reason why we have the caps. Just want to also mention something we have not talked about so much in previous hearings on this bill. You know, the cap started back in the mid-'80s at $350,000. It is now close to almost $1 million now, and it's been escalating at $15,000 per year. And significantly, the cap, today it's at $965,000. The cap does not end just at $965,000. The caps go higher under current law. In some cases, pain and suffering can be recovered by the victim and 2 or more beneficiaries, such as immediate family members. In these cases, non-economic damages in Maryland, the cap actually escalates under a multiplier to over $2.4 million. Non-economic damages are not even the sole remedy, as damages for the full and unlimited amount of economic damages and unlimited punitive damages may also be available. By the way, those economic and punitive damages, they were not mentioned by the proponents today. So we submit the rights of injured parties to recover for their injuries are protected under current law. Thank you, Madam Chair.
Mr. Collins. Are there any questions for this panel? Okay, seeing none, that concludes the hearing for SB 474.
Thank you.
Okay, we'll now turn to 541? SB 541, or whichever one the judiciary would like to take first. And who will be presenting this?
Depends which one we take first. I'm Matt Fader, Chief Justice of the Supreme Court of Maryland, and I thought it was 542. I don't know if I have my numbers correct, but a bill dealing with former judge temporary assignments.
If that's what you would like to take, that's what we will take.
Okay.
SB 542.
Here by myself on that one, so thank you, Madam Chair, members of the committee. We appreciate the opportunity to speak with you today. This is a bill that would allow judges to sit in senior status if they have won at least one election in the state. Currently, the law prohibits judges from sitting in senior status for any of several different reasons. One of those is if the most recent term of service as a judge ended as a result of a loss in an election. As you're aware, the only level of the Maryland judiciary that is subject to contested judicial elections is the circuit courts. An appointed circuit court judge must run in the general election that occurs at least 1 year following the vacancy that they fill. So at the time of an election, a circuit court judge will have served no more than 3 years in office and potentially less than 1. The winner of that election then receives a 15-year term of office. So at the end of a 15-year term, judges on average have served about 16 years in office, 15 of which will have followed that election win. It has come to my attention in recent years that a number of circuit court judges have decided not to run for re-election out of concern that they would be ineligible to sit in senior status if they were to lose that election. That's the reason why I'm here. The ability to sit in senior status is very important to the judiciary and to the judges who sit in that status. To the judiciary, senior judges are a critical resource that we rely on to keep our courts functioning. Our senior judges are among the most experienced judges that we have sitting in the courtrooms, with expertise built up over their years of service that is very valuable to the judiciary. To the judges, sitting in senior status gives them an ongoing opportunity to continue to contribute as the dedicated public servants that they are. It also gives them the opportunity to earn money to fill the gap between their pensions and what an active judge receives as a salary for being an active judge. But I will note that a number of our senior judges do continue to work after they've reached that threshold for no additional pay. So the ability to sit in senior status is important to the judiciary and to the individual judges, and the prospect of losing that ability for the rest of their lives has become a consideration dissuading circuit court judges from running for re-election at the end of their 15-year term. That gives rise to two concerns. The first is that when they step back from active service rather than running for re-election, the judiciary loses the benefit of their active service, which again is the service of judges who are on average the most experienced in our judiciary. They can, of course, continue to sit in senior status. That's why they might step down. But on average, that means that they sit only a third of the time that an active judge sits. And when they do it, they lose access to the dedicated staff they have that helps them be more productive when they do serve. They lose access to a judicial assistant and to a law clerk. The second concern with that is that I am not aware of a contested judicial election in which the sitting judge has lost since I joined the bench, where an issue in the election has been the competence, ethics, or temperament of the sitting judge. In other words, the reasons why judges sometimes lose are not reasons that should inhibit their ability to sit in senior status. From that perspective, I'm not sure what positive purpose a prohibition on sitting in senior status accomplishes when we're talking about a judge who ends service as a result of losing in a re-election bid. What it does is incentivize people who have a lot left to offer to step back early. If this change is made, it would still prohibit a judge who loses in their first attempt at an election from sitting in senior status. Those same considerations I've been discussing don't apply in that circumstance. So with that, I'd urge a favorable report on Senate Bill 542, and I'm happy to take questions.
Thank you very much. Senator Henson.
Chair. Thank you, Chief Judge. Can you get us some data on the number of judges that are eligible for election but decline to seek election because of, whether it's because of or not, the reason of fearing a loss and wanting to be able to sit as senior judges? But I would be really intrigued by the data on judges that are eligible but choose not to run.
I'm sure we can provide that. In looking at the sort of the second aspect of that, because it's really anecdotal when we get that information, I looked around and heard of at least 6 for whom that consideration was all or part of the reason why they did not run for re-election. Obviously, it's a reasonably small number, but of those, I'm not sure how many others there might be. But in my mind, that's too many when we're talking about a consideration that I don't think warrants an absence of an ability to sit in senior status.
When those 6 rose to your attention, did you do any probing to see if there was anything about their record as a judge that perhaps they did not want vetted or scrutinized in a contested election, to see if that was a reason why? I get we all understand campaigning and running for office should not be fun by anyone's standard. But was it anything particular that maybe they didn't want to be scrutinized in an election, and that was the reason why they took a step back from running for office?
I did not do any investigation. I certainly was not aware of anything that was a concern for that scrutiny. It was just really the fact that an element in their consideration was, if I run and don't win, then I won't be able to sit in senior status. But no, I did not do an investigation into any of those circumstances.
if that's a critical feature of being in the judiciary in Maryland, holding yourself out for the public vote, and those 6 members of the bench did not want to do that, does that have any bearing on your desire to bring them back as senior judges? Do you look at it and say, hey, if a person is not willing to do that and their colleagues are, maybe this is not a person I want to extend the senior judgeship to because they're not willing to go through the same rigors as their colleagues who have the opportunity?
That is not a factor that we consider. We consider their track record as judges on the court.
Thank you. Thank you, Madam Chair.
Thank you. Any other questions? Thank you, Mr. Chief Justice. That concludes the hearing on SB 542. Which bill would you like to take next?
Could we take next SB 544, which is the courtroom security personnel?
Absolutely.
And here I will be joined by a couple of other members of the judiciary. So, Madam Chair, members of the committee, thank you for allowing me to come speak to you about Senate Bill 544. I want to begin by expressing appreciation for your support 2 years ago for the Judge Andrew F. Wilkinson Judicial Security Act. That act has made a big difference here in Maryland and beyond. It's an act that's been copied in other jurisdictions by some of our colleagues in other states. Those protections have been and remain of critical importance, and we're very appreciative. One component of that Wilkinson bill is what brings us back here today. The law created a task force to study the safety of judicial facilities. The task force's challenge was to address 3 different areas to identify minimum acceptable security standards. As relevant to the bill we're here for today, one of those areas was security personnel in courtrooms. This was an issue and is an issue of critical safety, not just for judges, but for every single person who enters a judicial facility. Shortly after Judge Wilkinson's murder, I was looking for information to be able to provide my judges on maintaining their personal safety. One of the first things I was given was a pamphlet put out by the National Center for State Courts, which is a coordinating entity that supports state courts across the country. That pamphlet was on judicial security specifically. The first page of real substance of that pamphlet was on page 2, titled "In the Courtroom." The first bullet point on that page says, and I quote, "Do not conduct court sessions or hearings in the courtroom in absence of court security officials." This is information provided nationally to judges. That is, in fact, a correct standard for security. But if we were to follow that in Maryland right now, we would have a lot of dark courtrooms where proceedings need to go on and currently are going on. Across the circuit courts, especially in our largest jurisdictions, there are many courtrooms hearing family matters and other civil matters without court security officers present. And that's really important because family law cases in particular are among the most contentious that go on in our courtrooms and lead to the most threats and ultimate violence. In fact, it was a family law case that led to Judge Wilkinson's assassination. The task force met and identified a minimum acceptable standard for security personnel in the courtroom of at least 1 qualified security officer in every courtroom where a proceeding is going on, and a second in any courtroom in which somebody is there who is incarcerated or is at risk of being incarcerated as a result of the proceeding. And that there also should be an additional person for every 4 or fewer courtrooms on a floor so that there's additional support if needed. We came to you last year with a bill that would have put that standard in law as a mandate. What ultimately passed was a very sensible reporting requirement for entities providing security in courtrooms to identify how close they were to meeting that standard, how far they had to come, what obstacles might be in the way of them meeting that standard. The results showed that several jurisdictions were far from meeting the standard and that there are several obstacles in the way of meeting it. One, perhaps the most critical, is funding, which comes from local jurisdictions when we're talking about our circuit courts. And to be clear, we're talking mainly about our circuit courts here. Our security is provided in the trial courts by the district court, by bailiffs that are hired by the district court with funding provided by the state. We meet this security standard in all of our district courts statewide. Where we are struggling is in the circuit courts, where security is provided by local sheriff's offices who are funded in turn by their local county councils or city council. A second challenge is the difficulty of recruiting law enforcement officers right now, which is a challenge in Maryland and nationwide. Many of the sheriff's offices that provide that security have open pins right now. 3 of them have more than a dozen open pins for security officers to provide security in the courtrooms. We're working on multiple paths to try to address that, one of which is that we put funding in our budget this year for $5.6 million for a grant program that is intended to be available to help local jurisdictions meet this standard, whether that's for stipends for hiring or support for salaries or support for modernizing recruitment and retention systems. But that money would be available for that purpose as a way to try to get us to that point or try to help those local offices get to that point. But to fully implement the standard would require additional officers. This bill would identify the minimum security standard as a matter of state law so that everyone knows what that minimum target is. Unlike last year's bill, however, this would not establish a mandate that we know that there is not currently funding to make, and we, of course, we understand the recruitment issues as well. But what this would require is for jurisdictions to make their best efforts to meet this standard. So it is not an unfunded mandate, but it is still an important target establishing in state law what every jurisdiction should strive to meet. I want to end by expressing deep appreciation for the sheriffs and sheriff's deputies who provide security in circuit court courthouses across this state, as well as to the bailiffs who provide security in district court courthouses, and the special police officers at the administrative office of the courts who provide security in our appellate courts and in our administrative buildings. They all do great work, often with strained resources, and we appreciate their critical efforts to keep everybody who comes into one of our facilities safe. So I look forward to your questions, and thank you for your consideration. I'm going to turn the podium now over to Judge Wilson, who led our internal task force and has been integral in all of our security efforts.
Thank you, Chief Justice. Madam Chair, honored members, former colleagues. Thank you very much for the opportunity to address you today on this important matter. Several of you heard our presentation last year, and I'll try not to duplicate what was said at that time. Shortly after the senseless murder of my colleague, after the Chief Justice created the Judicial Security Task Force, and I was honored to be asked to chair that, we began an exhaustive search nationwide for best practices to determine how we could best advise our courts and security staffs to protect the people that use the courthouse, be it employee, judge, defendant, plaintiff, or simply public participant. We searched the National Center of State Courts, LEOSA, National Sheriff's Association, and several other organizations. We found perhaps our best source in the state of Georgia and the specific way they had modernized their court security protocols after the census tragedy of 2005 in a circuit court in Atlanta, when a criminal defendant who was on trial for a crime of violence, while in the back changing into his court attire, guarded by only a single deputy, overwhelmed the deputy, stole her service revolver, her service piece, pistol whipped her into a coma, broke into the back of the courtroom from an unsecured door, shot and killed the transcriptionist, shot and killed the judge, shot and killed a sergeant with the sheriff's department guarding the courthouse before escaping, and eventually also killing a federal agent before he was finally apprehended. Georgia took significant steps towards modernizing their security by codifying not only aspirational but actual protocols that were to be put in place in all judicial buildings. I apologize. I will wrap up by simply saying in Maryland, in just the last year, and in Washington County in particular, we've had several instances of whether it's bomb threats or other significant security threats where having the necessary number of people there is the only way that we can effectively remove people safely from the building and protect them. Thank you.
Madam Chair, members of the committee, good afternoon. My name is John Morrissey. I'm Chief Judge of the District Court. As you know, the District Court is a statewide court system that operates under a single administrative structure, and this allows us to implement uniform security standards across all locations. And the District Court bailiffs provide security for the courthouses, but very much like my colleagues in the Circuit Court, we face the same challenges with respect to recruitment and retention of our security staff. We strive to make it a great place to work by offering competitive salaries, but rising security threats make this work even more difficult. By not making this current bill, and you may hear from Sheriff Kogan, who testified over on the House side, that he felt this was putting him in a difficult position. It doesn't make it mandatory. It makes it aspirational what the goals are. And in the judiciary's budget, we've attributed $5.6 million as a grant fund to allow the sheriffs to make RFPs to us to say, here's what we need to fully staff these things. The threats are real. Just to give you a few examples for the district court, over the last year, we've confiscated 60 firearms, over 8,500 knives or razors, over 4,000 chemical sprays, and more than 2,000 tools. We provide security to 2.4 million members, either citizens or people coming to court here in the state of Maryland at over 33 different courthouses. In Wacomico District Court, we had a 9mm handgun tried to be brought in. On November 5th in Catonsville, we had a loaded weapon that was trying to be taken to juvenile services. And on March 10th, in the district court in Baltimore City, there was a 9mm gun that went through the metal detector with a round in chambers and 2 in the magazine. And if you remember last year when I testified around this time, an individual walked into the Eastside Courthouse in Baltimore City and committed suicide in the presence of about 30 individuals, including the public, staff members. It's a real problem. I hope that this committee can understand that we all are in this together, that we need to provide the required security, not just for judges and staff, but for everybody. It's real to everybody that comes into the courthouse, and I would urge a favorable report. Thank you all. I'd be happy to answer any questions.
Thank you. Senator West.
Madam Chair, I guess this question is for the Chief Justice. Mr. Chief Justice, thank you for coming. Thank you for bringing this bill. I think the fact that the bill includes the language used best efforts makes the bill easy for us to pass. But as long as I've got you here, I need to, and you referred to the Judge Andrew Wilkinson Act that we passed several years ago. I need to ask you, how's that working? Have you discovered any glitches, or did we do the right thing when we passed that bill?
You definitely did the right thing when you passed that bill. In my mind, it has been extraordinarily helpful. We have implemented, I think, very well the protections for personally identifiable information of judicial officers. So you may remember, we think that that's how the assassin of Judge Wilkinson got his information, finding it on the internet. We very much appreciate the cooperation of the various entities around the state that maintain information that had been available on the internet in allowing, in working with us to provide procedures to have that, all of that taken down. That part of the bill is working extremely well, and it's fully implemented and very active. The second part of that bill was a more stringent protection where a judge could get access that would also cover paper records and mailing if necessary, and that was viewed as only if there was a really, really serious threat that they needed to deal with. To date, nobody has taken advantage of that program, which I think shows how difficult it would be, but also how there's not a desire to hide everything. People can have access to information when they need it, but it was really the taking the information off the internet that is the primary way that people found that, and that has been very useful. The other aspects of that, we're setting up the task force, which this is one element of that, of what the task force looked at. The task force also looked at issues dealing with parking, with basically how do you get from a parking area that is remote from the courthouse to the courthouse. We have, in some of our jurisdictions, judges have to park somewhere and then walk a couple of blocks to the courthouse along with people who they are going to see in court that day, or people they have seen if they're going the other way, or have to walk across the street to a car parked across the street. And so that is something else, and there were recommendations made for those facilities. And then the third area was general courthouse safety and what other issues there are in securing our courthouses, really looking at the physical structures and the procedures and things like that. With respect to those latter two areas, frankly, we wanted to because all of them are resource intensive, we wanted to have our greatest efforts be dealing with what we thought was the greatest priority, which is security in the courtrooms. So knowing that this is going to take some work and funding, we've placed the greatest emphasis on that first. We have been working on those other issues because we did do assessments of every courthouse in the state to identify, we had 282 questions that we needed to have answered to identify whether minimum acceptable practices were being used to protect those courthouses. We gathered all the information and analyzed it and have a list of projects that we're working through. we ultimately will hopefully come and ask for more support for that effort to make sure we tick off those items in the future. Right now, we're working through them, but we wanted to come first to address the highest priority issue of security funding. So a lot of good has been done as a result of that bill and is still being done.
I appreciate your answer. Thank you.
Thank you. Seeing no other questions for this panel, thank you all. And
thank you.
Judge, former Delegate Wilson, it's nice to see you again.
Good to see you.
Next, we have Melinda Gallier.
I am not Melinda. She is my assistant. I am Marisa Trissetti, and I'm president of the Maryland State Bar Association. Thank you. Good afternoon, Madam Chair and members of the committee. The Maryland State Bar Association is about 17,000 members strong. We represent and are the biggest statewide organization representing legal professionals. Court security and access remain a core priority for the MSBA. Justice depends on everyone's safety. Judges and attorneys must be able to decide and present cases respectively without concerns for their welfare. Litigants must be able to come to court and seek redress without fear. A 2024 survey of state judges nationwide, some statistics, found that over 82% worry about their safety and over 56% have been personally threatened. We can do better. Nationally, the U.S. Marshals Service reported 176 threats in just the first month of 2026, showing an escalating trend of violence in the judiciary. For our members, the courtroom is their office. They deserve a safe workplace. They should not have to navigate threats and violence in courtrooms or fear walking in and out of parking lots as part of their professional lives. Our members cannot opt out and choose not to appear in court. They have taken an oath. They have a duty to represent their clients in high conflict situations, making standardized security a necessity. For all of these reasons, we urge the committee to continue its commitment to court safety. We thank you for your commitment and respectfully request a favorable report on SB 544.
Thank you. Any questions from the committee? Okay, seeing none, we will now move to favorable with amendments. Sheriff Kogan.
Thank you for letting me be here tonight or this evening and testifying on this important issue. First, I want to say I agree with everything that the judiciary said and the Bar Association just said. Court security is a very significant issue. We have, I just recently received from the Department of Homeland Security a memo talking about increased judicial threats around the country, and we should expect to see that increase over the next 5 years without a decrease. So I'm favorable with these court security standards. I believe in them. I was on the task force that helped, emphasize that that's what should be created. The issue here, and I think it's the elephant in the room, and that this is why I have to speak up, is that I believe that setting aspirational standards or these standards and saying, well, Sheriff, just do your best effort to fulfill it, right, and not including the funding piece really is highly problematic, right? So when we look at it, we look at where's the issue? The issue is with sheriff's offices. And why is the issue with sheriff's offices? It's because the local government isn't prioritizing court security funding, right? That's what it is. And so this really puts me in a terrible position with my mayor, right, and a terrible position, in my opinion, with the judiciary to say that there's going to be this standard that I'm not, I go in front of the mayor and city council and say, listen, I need this amount of pins to make this, I need the funding to do what you want me to do, and I want to do it, but you're not providing me with that funding, right? And so, I think that's the issue, right? I don't know how we can move forward on a standard where there's nothing that comes with it to say, Sheriff, this is how you do that, and expect there not to be problems and this really to be dumped on the heads of all the sheriffs. I don't think there's any sheriff in Maryland that wouldn't want to, if they were funded, to put a court security officer in every courtroom with the judge, wouldn't do it, right? I know I would do it. I'd be happy to say, and I have done this. I've looked at every single courtroom I have, and I say I need a person for this, and here's what it costs, and every single door at the courthouse, and this is what it costs, and broke it down in the most transparent way that you could possibly break it down in life. down to like the hour that they're there and when the courts are closed on the holidays. And I know exactly what that would cost. And I go and say, please let me have it so I can protect the judiciary. And I don't get it, right? And so what do we do in that situation? And so part of the reason I'm here with the amendment is also to ask for relief from the Senate, right? To say like, hey, I'm in this situation, right? The judges deserve to be protected. The courts deserve to be protected. The local governments are not funding court security to the level that they are. We have the standard, which everyone believes is best practices and what we need to do, but how are we going to fund it? And so with that, I think I can take any questions that anyone might have.
Thank you. Any questions from the committee? Okay, seeing none, thank you for your time. We will now move to the unfavorable. Sarah Sample.
All right, thank you to the chair, members of the committee for having me. My name is Sarah Sample, here from the Maryland Association of Counties, and we are here in very unfortunate opposition to Senate Bill 544. Again, what I want to start with is that this is not an opposition to the purpose of this bill. It's basically the process in terms of how we got here. And so I'll just walk you through a little bit of how this has gone over the last about 18 months. Last year, there was a bill that was an unfunded mandate, and it had to do with courtroom security and meeting these standards. We didn't know what that cost was, but we did a support with amendment because we were like, this is really important. We'd like to know what the cost is. We'd like to know what the vacancies are. And we would like the state to help out a little bit on that. That bill turned into a requirement that I believe the sheriff's departments had to send in what those vacancies were. And I was told over the interim, go get those numbers. We want to know what they are. Maybe they're not that bad. Maybe we can figure it out as long as we get that information during our budget period. So basically getting it in January and February. I had made contact with a number of different organizations that had this information. I was told that we couldn't have it or that they wouldn't give it to us, or in some instances didn't get a call back. So we were feeling like we were trying to make a really good faith effort to get this to a good place. And then we saw this bill come in this year, so sort of flash forward. There are elements of it that are unclear that sort of read like it could be a mandate. And then we were left with no information, and so they were frustrated, and that's why we ended up taking the position to oppose. I will say that I did get a call this morning after we took the position to oppose that they are willing to share the vacancies with us. It's unfortunate that we had to go to that extent to get them. But I think, we want to be a good partner, but we can't fund these things if we don't get that information. And again, from my call this morning, they shared some clarifications about the grant options. I think that's helpful. But yeah, unfortunately, that's why we ended up in the position to oppose. So, thank you.
Thank you. Any questions from the committee? Seeing none, thank you for your time. And that concludes the hearing for SB 544. And I gather we're turning to SB 543?
Yes.
Okay, great.
And I will be joined here by a couple of others as well. So thank you, Madam Chair, members of the committee, for the opportunity to be here to urge a favorable report on Senate Bill 543. The judiciary is asking this year to add 2 judgeships in the state. The circumstances of one of those requests is a bit unusual, although it's the same as I was here last year, but I did want to be able to be in a position to explain that. But first, we are requesting a new judgeship in the District Court of Maryland in Washington County. Our judicial needs analysis that we conduct every year has shown a need for a new district court judge in Washington County for several years. We have not come to you asking for a new judge there before because there wasn't any room in the building. Now, however, we finally have a project to add more space in that courthouse underway that will allow the court to be fully staffed for the first time in several years and alleviate strain on the current bench. Chief Judge Morrissey is here, and we'll talk more about that in a moment. The second new judgeship we're requesting is in the Circuit Court for St. Mary's County. That is the spot that takes a little bit more explanation, although you may remember the same explanation that we provided last session. The judiciary traditionally has asked the General Assembly to authorize new judgeships only when the methodology that we employ and have employed for decades, which is based on a model provided from the National Center for State Courts, certifies a need for that judgeship. That methodology is based on an assessment of how long it takes to handle different types of cases across the state and the number of those cases that are filed in each jurisdiction from year to year. We apply a rolling 3-year average in coming up with that estimate. We're currently using a model that was completed in 2017 with a partial update in 2022 for that purpose. This year, the assessment certified a need for 5 new judgeships. For a variety of reasons, including space limitations in other courthouses, we're requesting only one of those new judgeships, that being the one I mentioned in Washington County. In addition to that, 4 circuit court jurisdictions requested additional judgeships, requested that the judiciary make that request on their behalf, even though the model did not produce a certified need. Those are Queen Anne's County, Harford County, Charles County, and St. Mary's County. We are not requesting judgeships in 3 of those jurisdictions. To be clear, each of those 3 jurisdictions has made a good case for needing additional judicial resources. However, the bar for the judiciary to make such a request when the model does not certify a need is extraordinarily high in order that we maintain our credibility with you in adhering to that rigorous methodology. Given the cases that the jurisdictions have made, however, concerning the need for additional resources, we are accelerating the process of updating our model to ensure that it does accurately reflect need. The results of that update will be available next year. We expect to have data for you then that takes into account the changes that have occurred over the last 9 years since there was a full update of the model last time in 2017. In the meantime, though, the Circuit Court of St. Mary's County's request cleared the high bar that we have for requesting a judgeship when the model does not identify a certified need. That is because there have been demonstrable changes in that court's workload that we know are not reflected in the model. Perhaps most significantly, owing to policies in the Office of the State's Attorney for St. Mary's County, the Circuit Court for St. Mary's County's criminal jury trials increased by 261% from calendar year 2019 to calendar year 2024. That's particularly significant because the model we employ to analyze the need for new judgeships is based on initial filings in the court, not on what happens to those filings after they are made. It does not take into account jurisdiction-specific changes that make cases take many more resources in some jurisdictions sometimes than others. A case that goes to a jury trial obviously takes a lot more time and resources of the court than a case that's resolved by a plea agreement. So that 261% increase is not accounted for in the model, but is significant when it comes to the resources needed to address timely the needs of the citizens of that jurisdiction. St. Mary's County has also seen a 62% increase over that same period in family law merits hearings, which similarly is not accounted for in the model that is based off of filings. In spite of efforts to address that backlog, those and other changes have not allowed the court to do so. In that regard, I will turn it over next to Judge Stanalonis, the administrative judge for the Circuit Court for St. Mary's County, who can provide more information about what they are facing. I look forward to your questions, and I thank you for your consideration.
Good afternoon, ladies and gentlemen of the committee. I want to thank you very much for giving us this opportunity to present. As the Chief Justice has indicated, St. Mary's County has seen a tremendous increase in the number of jury trials over the last 3 years. In the first year under the new state's attorney, we did not make any request for an additional judgeship. We wanted to see if things would settle down and if it would go back to normal. To give you an example, prior to this state's attorney, in a typical year, we would have criminal jury trials maybe 2 weeks out of each month and anywhere from 10 to 12 criminal jury trials in a year. Under the current administration, we are having criminal jury trials 3 to 4 weeks a month, and we are having 2 or more criminal jury trials actually happening each of those weeks and requests for many more. To give you an example, last week we had 25 cases scheduled for potential jury trial. Of those, 11 requested to have a jury trial. With the use of a senior judge, we were able to accommodate 6 of those trials. The remaining cases had to be continued to a future date, and that's been happening week after week, month after month, and now year after year with no end in sight. The numbers that the Chief Justice gave you were up through 2024. And I can tell you that last year they were higher, and this year they're continuing to rise so far. That impact is also impacting the rest of the court as we're using all of that time for jury trials. Civil cases and family cases are being impacted as well. To give you an example, if you came in today and said, I need a day with a judge for a merits hearing in a child support or a custody case, it's about 1 year from now before I can give you that date. So if you are the parent who isn't getting access to your child, you're going to wait a year before I can get you in front of a judge. If you are the parent that was left high and dry and needs child support, you're going to wait a year before I can get you that judge. So we are struggling to try and get these cases moving and keeping them moving. All of our judges and magistrate have agreed to start early. So for those of you who are attorneys, you know most courts in the state of Maryland start at 9 o'clock, take a lunch recess, and usually finish between 4 and 5. In our courthouse, we're typically starting at 8:30. We're going through the lunch many days, and we're staying late many days, and that's in the courtroom. That doesn't include the work that we have to do in chambers, which we are doing late into the evening, into the night, and on weekends. So we are fortunate that our commissioners, after last year when we were not able to get the position, our county commissioners still agreed to fund the modifications to our courthouse, so we have a courtroom available. They have agreed to provide the increased security, a bailiff, and administrative personnel to support the judge. We just need to get the legislature hopefully to fund that mandate, not just for us as judges, but for really the citizens of St. Mary's County who are struggling to get access to court. And I'll be happy to answer any questions after Judge Morsi.
Good afternoon again, Madam Chair and members of the committee. For the record, my name is John Morsi, and I'm the Chief Judge of the District Court. Washington County has had a certified need for another district court judge for over a decade, but we've hesitated to ask because you need a chambers and a courtroom before you can really properly have that. My administrative judge for that district, which includes Frederick and Washington counties, has been needling me that they've built a minor league baseball stadium across the street from the courthouse in quicker time than I've been able to build a third courtroom on this existing courthouse. But I'm delighted to say that we're going to break ground in March of this year. So finally, long overdue. It is a design build. It's a 2-year plan. We've completed over 80% of the design, so we will lay shovel in the ground in March of this year. It'll be a rehab of the whole mechanical system of the court. Then we'll build out courtroom 3. Then we'll rehab 2 and 1. And then we'll take care of the HVAC. So we're basically getting a brand new courthouse almost for the very minimal price compared to what it would cost for an entirely new courthouse. To give you a scope, there's 2 judges currently in Washington County, one of just which retired, Judge Mark Thomas, who was in my baby judge school class, and Victoria Lobley. In the last fiscal year, they heard over 13,000 traffic cases, almost 4,000 jailable traffic cases, more than 5,000 landlord-tenant cases, disturbingly more than 1,100 domestic violence cases, and over 600 peace orders. They disposed of 3,800 criminal cases, over 900 DUI or DWIs, and over 5,400 civil cases. In addition to these main case types, these judges will issue over 1,000 writs, renew 1,400 summonses, will hear natural resource cases, municipal infractions, civil citations, ERPOs, emergency evaluations, fugitive warrants, and more than 1,400 bail reviews. They'll hear rent escrows, forfeiture of counterbands, petitions to strike bond forfeitures, extraditions, violations of probations, witness warrants, body attachments, preliminary inquiries, and probable cause hearings. That was what they do over the course of a year. They're well exceeding 100% capacity of a judge in these studies that we show. It's well above 110%. So they're doing more than most judges do typically. And I'd like to express my gratitude for their hard work. They haven't complained very much. Every once in a while they kind of squeak, but I really do appreciate their patience while we've been waiting for this third courtroom to be built out. I would urge this committee with a favorable report. Thank you. And I'd be happy to answer any questions.
Thank you. Senator Charles.
This is for Chief Judge Fader. So I just heard 1 year to get a hearing on any type of issue. That's a long time. That's crazy. I know in Prince George's County, we run into some of those same issues too, with long drawn out cases before you can get in front of a judge, which ends up hurting a lot of families. And one of the things that we do here when we get a lot of folks that's coming in to provide testimony on a bill, we have to hear every single person in the state. But we put time limits, you know, to make sure that we can get folks in and out of here and make sure people are heard. Has the court looked at any way to truncate some of these cases and limit the amount of people that can come in, limit the amount of time on testimony for folks that are coming in to address issues. 'Cause you know, people like to pontificate. And so they'll say the same thing over and over and over again about 20, 30 times. And you done wasted about an hour, 2 hours of your court day. And it just hurts a lot of other people. How do we address that? Have you guys started looking at ways to change how the court deals with hearings?
So, I mean, a judge operating a courtroom will manage that, and certainly judges do prevent people from having duplicative testimony in circumstances, and they can, streamline questioning and things like that. Those are courtroom management techniques that trial judges use all the time. But of course, there are due process rights that people have when they have their cases come in both criminal and civil settings, and so there are limitations on what can be done in a courtroom to manage the proceeding based on the need to make sure that everybody has due process rights. The people, Judge Santalone has talked about people in custody hearings. Those are really serious hearings where custody of somebody's children is at issue, and you need to hear them out in order to be able to make those decisions. So I'd say yes. I'm sure that the judges there are managing their courtrooms as effectively and efficiently as they can, and making those decisions to avoid duplicative testimony. But there are strong and really important limitations on their ability to do that because of the really significant issues that are presented.
Does it really need to be set at 3-day trials though for custody hearings? It's fact A, fact B, make a decision. Or hear 2 or 3 people on the issue and make a decision. I say all the time that in the appellate courts we have a much easier job than our trial courts do. We get to take 4 months to try to figure out a decision that a trial judge might have made in 30 seconds, whether it was right or not. Our trial judges do really, really hard and important work all day, every day in this state, and they need to hear the testimony that they need to hear in order to be able to effectively make that decision. And I know that they try to manage their dockets in order to make them as efficient as possible. But when the custody of somebody's children is at issue, you just can't cut off testimony that you need to hear in order to make sure you're making the right decision in that case. Yeah, I think about the 1-year time period for a custody hearing. The amount of time, if you have parental alienation going on and one party keeps the child away from the other parent, and you can't get to see your kid for an entire, not even see your kid, you can't even get in front of a judge for an entire year, and to get a pendente lite hearing just to get a temporary custody order. Is there a way for you guys to probably move up pendente lite hearings and then allow for, a temporary order to be set so a year doesn't go between a parent seeing their child?
I can turn it over to Judge Santalones for the particulars of that, but to the extent that you're saying that a year is too long, we agree. There's no disagreement here at all. That's why we're here, in order to try to get the system so they can work through that backlog and provide more timely and efficient service. You're going to get no disagreement from me that that's too long.
No, and I'm happy that we find agreement on it. But if it's going to take 2 years to build a courtroom, how do you address that?
Not there. They have the capacity now, based on changes that they've made in St. Mary's County, to have this new judge have a courtroom and a place to be. That's an issue in Washington County that we've been dealing with. We don't have that issue in St. Mary's County.
Okay.
Senator Charles, this sounds like it is relating to another bill, so perhaps you want to take this offline and
No, I
talk
was
to
just
the
looking
judges.
at their in terms of the amount of time, but we can take it offline.
Great, thank
and have
you.
a longer conversation.
Thank you. Any further questions for this panel? Okay, seeing none, thank you all very much. Andrew Neal.
My bad. Let's get us out of here at 5 o'clock. It's 4:11.
Good evening, Madam Chair.
Mr. Bariano, I have Andrew Neal is favorable, and I have you as favorable with amendments.
The sheriff meant to do favorable with amendments. It was a technical apology. They were not familiar with doing that.
Okay. And so you're going to go.
Apologize. We're favorable with amendments.
Okay, so you're going ahead of the sheriff?
Yes, with your permission, yes.
Okay, go ahead.
Thank you. Madam Chair and members of the committee, for the record, Bruce Beriano, here on behalf of Queen Anne's County Commissioners. We support this legislation, have no disagreement with it, but we have an amendment which I'll be submitting to the committee, adding Queen Anne's County for a circuit court position. I am very mindful, Madam Chair, that you heard Senate Bill 358 a couple of weeks ago. I'm just trying to do my job as effectively as possible. We're not going to repeat everything like that, but that is another vehicle legislatively. And all I want to say is that just two points. Queen Anne's County situation is exactly as difficult and adverse as St. Mary's is in terms of the particular individual that in doing their job has created a need for much more work up in the circuit court, which we explained in our previous hearing. The model that was used is a model out of North Carolina, which considers a lot of things, but they don't understand locally what the problems and the situations are. Lastly, I would just say, just to remind, because I think it's very salient, is that back in 2016, we tried to get a circuit court judge. The administration said you need another courthouse. We built another courthouse at the expense of the county commissioners. There are 2 full courtrooms. We're using it for visiting court judges right now, but it has been existing. It's been there for several years, and the model just does not reflect local realities in terms of the pursuit of justice and the effective use of courtrooms. So we will submit the amendment. We also have our bill. Bottom line, we really need a circuit court judge. Thank you very much for your courtesy.
Madam Chair, members of the committee, thank you for having me. I'm Sergeant Andrew Neal with the Queen Anne's County Office of the Sheriff. My current role is the Circuit Court Security Team Supervisor. I'm here on behalf of Sheriff Gary Hoffman and Honorable Lynn Knight at the Circuit Courthouse. Each year, nearly 500,000 visitors travel to or through our jurisdiction. Over the past 5 years, travel and commerce in our county have increased by more than 33%. With that growth comes increased responsibility. The Sheriff's Office responds to nearly 42,000 calls for service each year. At the same time, our judicial system is experiencing unprecedented demand. Currently, our courts consist of 1 district court judge, 1 circuit court judge, and 1 judicial magistrate. In recent years, we have seen 129% increase in the filing and issuance of civil and domestic claims. Criminal filings have also risen. Each of these cases requires time, attention, and careful judicial review. These increases place significant strain on our court staff, our judicial resources, and the timely administration of justice. In June 2019, Queen Anne's County completed construction of the new circuit court facility. The courthouse was intentionally designed with the foresight to allow for expansion, including the addition of a 2nd circuit court judge to complement the dedicated service currently provided by Honorable Judge Lynn Knight. At that time, we were preparing for growth. Today, that growth has arrived. Queen Anne's County has taken a realistic and responsible look at our needs. We're not asking for expansion without cause. We are responding to measurable increases in population, travel, commerce, and judicial filings. Justice delayed is justice diminished. Our residents, our businesses, and our law enforcement partners depend upon a court system that can respond efficiently and effectively. The addition of a 2nd circuit court judge would align our judicial resources with the realities we face today. It will reduce case backlogs, improve scheduling efficiency, and ensure that our citizens receive timely access to justice. We are proud of our county, we are proud of our partnerships, and we are committed to ensuring that our growth is met with the appropriate infrastructure to maintain public safety and judicial integrity. Thank you for your consideration and your continued support for Queen Anne's County.
Thank you. Any questions for this panel? Okay. Seeing none, that concludes the hearing on SB 543.
Thank you.
And we'll turn to our last bill of the day, which is SB 541.
Good afternoon, Madam Chair. Thank you for welcoming me today. My name is Ann Albright. I am a judge of the Appellate Court of Maryland. I am also the chair of Maryland's Commission on Judicial Disabilities. Today, I'm honored to be joined by Tanya Bernstein, who is the director of the commission, as well as our investigative counsel, and she's here to answer questions that you may have. Thank you for taking time to hear us today. We are here to testify in favor of Senate Bill 541 on behalf of the Maryland judiciary. And thank you to those who have sponsored the bill. The Commission on Judicial Disabilities is an independent body that investigates complaints of sanctionable conduct, disability, or impairment by Maryland judges and justices. And when warranted, we can conduct formal public hearings about those complaints. Where clear and convincing evidence of such conduct is found, we have the ability to take or recommend actions against that judge or justice to the Supreme Court. Removal from office or compelled retirement are the most serious sanctions that we can recommend. They require findings, conclusions by the Commission and the Supreme Court of Maryland. In order to recommend removal, the conduct must be so serious that the conditional diversion agreements, the reprimands, the letters of cautionary advice, in other words, the alternatives, are all insufficient. This kind of conduct could include racism, sexism on the bench, sexual harassment, accepting bribes, criminal conduct, or intoxication during hearings. Levying sanctions, especially removal, is not a responsibility that we take lightly. We investigate complaints thoroughly. We defend the due process rights of the judges who are the subjects of those complaints. We collect evidence in a fair and neutral way. Recommending removal is rare. Through the exercise of our powers, the Commission promotes the public confidence in our bench, preserves the integrity and the independence of Maryland's judiciary. But there is a gap. There is a gap in what we can do, and that gap remains in our ability, causes us to have a gap in how we fulfill our mission. Right now, a judge or justice who is removed or retired remains eligible for future appointment or election to judicial office, regardless of the gravity of their conduct or their ability to perform their duties. And we ask, how can Marylanders trust their rights, or trust that their rights are being upheld by the courts if their hearings are presided over by a judge whose impartiality and performance warranted their prior removal? This is why I'm here to testify in favor of this legislation. Put simply, this bill would, it's a constitutional amendment, so if adopted by the voters, it would prevent the judges and justices who have been found unable to perform judicial duties from serving in judicial office in the future. 25 other states already prevent removed judges and justices from returning to the bench, either for a fixed term or permanently. States vary on whether the disqualification is automatic upon removal or elective, but the measure before you would be automatic. I would be happy to provide additional information on the procedures employed by other states at the committee's request. Preventing judges and justices who engage in the gravest sanctionable conduct or are unable to perform their duties from returning to office is critical to defending the integrity and reputation of the bench in Maryland. And for that reason, on behalf of the Maryland judiciary, I urge a favorable report. We are happy to answer any questions you may have. Thank you.
Thank you, Judge. Are there any questions? Yes, Senator Henson.
Thank you, Madam Chair, and thank you for your testimony, and it sounds like the very thoughtful work that you do. Question, when a judge is found to have a disability and then I guess is removed, This committee, we do a lot of work by way of justice reform, by way of second chances, by way of looking at our criminal code to see what opportunities exist once people have rehabilitated, once people have, gained the tools to be able to make different and better decisions in life, to give them the opportunities to benefit from those tools and make different and better decisions. So if a judge is removed by way of disability and then time has passed and they have recovered from that disability, if we are putting in place a permanent bar from them being able to serve again, whether that's by appointment or election, because they could be elected, they could stand in a contested election, and if they have the confidence of the voters, they could be placed in by the confidence of the voters. If we are permanently taking that option off the table, notwithstanding any sort of demonstration that they have rehabilitated, how do you think that jives or how does that reconcile with the work that this committee has done to give second chances to individuals who have shown that they've rehabilitated in a criminal legal context?
Ms. Bernstein?
Thank you, Senator. That's a very thoughtful question. And I'll answer it in this way. The way that the rules that govern the judicial discipline process, they define and make a distinction between an impairment, which is a type of not necessarily a disability, but a type of something that the judge may be suffering from that would temporarily affect the judge's ability to perform their judicial duties. Whereas a disability would be a permanent disability that the judge could not, in a permanent way, fulfill their judicial disabilities or their judicial duties. So I think we have to look at it in that context, that I think in the way that you're talking about, if a judge can kind of be reformed or otherwise be able to come out of the impairment, I don't think that the removal is going to be a sanction that's going to be imposed, because there's other mechanisms that are available to be able to, for the judge to be able to come back, to be able to fulfill their judicial duties in an impairment situation. But the removal process would be something where we would be talking about a permanent disability, where there would be no rehabilitation, there would be no way for the judge to be able to get back to a place where they would be able to fulfill their judicial duties in that context. So I think that we're making a distinction there between impairment, which would have other mechanisms that the commission could employ to allow the judge to be able, either through medical treatment or other sorts of education and training, to come back to that 100% ability, versus a disability which would be determined medically to be something permanently affecting the judge from their ability to serve.
Would you say that your ability to make those sort of distinctions is affected by the quality of the representation or the presentation that the judge is able to put on in their own defense? If a judge is able to afford counsel and that counsel is able to subject them to expert witnesses and testimony and get them evaluated, and they're able to do that and present you with a lot of evidence where you can make those determinations, do you have the ability to better determine which category it fits in based on the quality of the defense that the judge is able to provide for themselves?
I think that's certainly a subjective analysis and something that we would look at on a case-by-case basis. But I would say, even if the judge was not represented by counsel and was simply representing themselves, or where there was some sort of concern with their ability to represent themselves, there are a couple mechanisms in place in the rules currently that allow the commission, one, to appoint counsel on the judge's behalf, where the fees would not be paid. The cost of the fees would be covered, and the judge would not have to cover that. So there is the ability to appoint counsel in those circumstances. Additionally, if we're talking about some sort of medical impairment or disability, there are mechanisms by which the commission can order an independent medical or mental examination that also would be something that could be covered by the cost. The cost would be covered via the commission as opposed to the judge, so that there would be the evidence and the medical determination available to the commission and ultimately to the Supreme Court of Maryland, who would be the ones, the body that would be making that ultimate decision as to whether the judge could fulfill their judicial duties on a permanent nature. There would be that ability available even if the judge could not afford counsel or did not have counsel of his own choosing.
There was a commission that was studying contested judicial elections. Did the judiciary participate in that and take a position on what Maryland should do with contested judicial elections?
I believe so, but I was not part of that, so I could not answer to that specifically.
Okay. I think the judiciary, the work that the judiciary was a part of it, and kind of the final work product from the committee was specific recommendations, but embedded in the recommendations were to more or less not do contested judicial elections. And I gotta say, this bill, Senate Bill 541 and Senate Bill 542, they seem to undermine the process of contested judicial elections as well, because what it's saying is that if a judge is removed, even if it's the will of the voters to restore that judge, even if they can make their case to the voters and the voters want that person to serve in that capacity, that because the judiciary has removed them, that they should no longer have the opportunity to serve. And in Maryland, we have a unique system where people can take their case to the voters, and this would remove that opportunity. In the other bill, which is not the one that's before us, but it says that if a person does stand for election and they're not successful in that election, that the judiciary could just bring them back as a visiting judge, and they could then return to service again. So I know that that's a broader issue that we'll have to continue to consider as a body, but it does seem that the two of them are definitely leaning in a specific direction, but I do appreciate the deeper understanding of what your process is like and how it might affect that. So I appreciate it. Thank you, Madam Chair.
Thank you.
Thank you. Senator James?
Yeah, this will be very, very quick. Just want to confirm, because we talk about removal and retirement under this bill and the section. So with removal, as I read it, the terms of that removal, like benefits and spouse, you don't always want to punish a spouse, right? The court has discretion, the Supreme Court has discretion to decide how to treat the spouse and even the removed judge, I suppose. But if it is retired, which would be generally from a permanent disability, you don't have to remove them, then just so I'm sure, that judge retains and his spouse retains all the privileges and benefits they have accrued and are entitled to, because there's big difference, right?
Yes, that's the way the law is currently. You are correct.
Okay, that's all I needed. Thank you.
Thank you. Seeing no further questions from the committee, that concludes the hearing on SB 541, and that concludes our hearings for the day. We're adjourned.
Thank you very much.